Item number 21 of the Dr. Sparking list. Number 5 has been handed last week, and unfortunately, I have taken a leave of absence from the for the next 10 days. I anticipate the mutton not be all till the 20th. It may remain in the list, but till 19th, I have some personal difficulty.
Okay.
Part 2, item 21.
Item 21. All after 21st.
I will give the word.
I'm suffering from my life.
15. So this matter, I think, is something. There was a previous order. You have to do something.
I'm suffering from life.
Okay. Council today is paid for by say how much the council to the petitioner. Okay. You're for the petitioner. Okay, one says a representative or the player maybe comes for the petitioner just after 2 weeks. Yes.
NAD after 19 or NAD after 19 will be continued.
From 18 of the from 18 onwards, for 18 member
No, if the advocate general is not there, we can't fix it. You have heard her.
NAD after 19.
You agree to a date after that. It says that it's agreed to which is this term.
Twenty
25th. Okay, 25/9/2023. Okay. Yes. Due to the postmaster. What was the last order passed in this matter?
Okay. That other loans are given visual. So why should railway loan also give this?
Okay. You want it after a week? On the plain mid-measure council for the appellant. This one 25/9/2023. Okay.
item number 3 lost.
3.
Item number 3 you lost. The candidate number 3 is lost because I need to find some additional documents.
Okay. After
2 weeks.
this after 2 weeks as paid for by council for the additional. Okay.
You go ahead. Direct to action, item 19.
19 years. This is a matter before any other bench without me. Without one of us.
Item number 1 for Muson. In Golpara district, there is one hill that is called Chikalmari Kontao Hills, and another is called Naitara Hill. One is wetland, one is hill. And because of the anti-environment activities, these are hard of activities. That's why this PI has to be
Issue notice for Mr. T.J. Mahapur, Senior Counsel and Standing Counsel of this court. Assisted by Mr. A. Baba, Counsel for the General Instructing Counsel. Next. We have the issue raised in this PIL, issue notice, returnable in 3 weeks. Mr. P. Goswami, the additional division assisted by Mr. I Kalita, Counsel for the Environment and Forest Department.
Secretary also there and we are
Watch it. For the access also on the behalf of the respondents. The respondents, along with their activity in opposition, shall also produce the, what is it called? The plan, what is that plan called?
mining plan.
Mining plan.
Environmental clearance and mining.
Environmental clearance and mining plan. In respect of the quarrying activities, so stone crushing and quarrying activities carried out in Chota, CHOUTARA, Nata, NAITARA, Bill, and Sitamari, CHITAL, Bonga, BONGA, Hills, Golpara district. List after 3 weeks. The learned instructing counsel for the petitioner shall provide extra copies of the application to the instructing counsel for the AG. Okay, the registry shall also reflect the name of the additional division in the and this instructing counsel for the cause this for listing matter next. This item 2.
Item number 2.
Yes.
Very strategic incident.
No, but still we'll have to.
We'll have to take a call.
No.
Inspection.
I'll show you. I'll show you why. Let the registry what you call put up a note on the basis of which we'll initiate this PIL. You look at this initiator of the PIL in this first page. No signature. Next page is a photocopy. It's all politically smooth matters.
But it went through the
No, it's okay, but we are taking a judicial call.
This I did not, but I don't have a copy of that.
The political leader who is moving this
But
did not care to sign it.
No, this is not fair. This is not fair.
So the registry can put up the note at your instructions.
Not
But the issue is
issue is serious. Otherwise, also
dehouse this, my lord can then proceed. Without going into that letter, my lord can have the PIL in a fresh form. This will be the solution.
But there has to be a,
There has to be a,
no, not that, some note has to be there.
my lord, this will go, but it will have to go back to the registry to the PIL committee and then come back.
No, PL committee is not required because it has already taken a call.
Ah,
So we will just ask this to be removed.
lordship. That letter will be
Annexure 1 will be removed.
lordship.
Uh, This you can ask him also. The Standing Council of this court, assisted by Mr. ACT, Government Council. Next paragraph is noted that Annexure 1, on the basis of which this PIL was initiated, does not have signature in the first page of the letter, and the second page is a photocopy. Poster. It endures that said communication dated 20 unsigned communication dated 28/6/2023. The issue raised in this PIL is a serious issue. That's therefore. As the Annexure 1 is, as first page of Annexure 1 is unsigned, and the second page is a photocopy. The registry is directed to remove the said Annexure 1. And Annexure 2. And this here is accepted on the basis of note put up by the registrar within the judicial. Dated, and note of the registrar judicial, they are dated 31/8/2023. Shall notice returnable in 3 weeks. What is the extra purpose of you are accepting notice for the state? For state will be accepting. You are there. Your name?
SQR.
SQR. The committee will get access notice on behalf of all for the respondents. What is the extra purpose of this? PIL, divorce Annexure 1 and 2 provided to her within 2 days. Next one. During the prior to the executive listing from the state shall conduct an inquiry and the report will be placed before this court through the government advocate, land government advocate.
Inquiry pertaining to the death.
Content.
And also, my lord will direct the deputy commissioner and give a report with regard to the coverage of the schemes, poverty elevation schemes in that area, especially with regard to this.
Okay. Query with regard to the death of Srimati Saruma, SARUMAI, Iang, of Salmara village of Lakhimpur district. On the next day, the deputy commissioner, Lakhimpur district, shall also apprise this court about the poverty, why the poverty elevation schemes did not reach the family of the victim. We take note within 3 weeks.
Yes.
Number 4.
Just Yes.
Lordship, in this matter, Batra that is appearing. A series of school registers were sent for investigation to the CID. 14 of them, out of which 12 were found to be fabricated. So a CID report is awaited in this matter. Everything is not report Lordship. So Lordship will fix up a date. Or Lordship can fix a timing or maybe next week, Lordship. Because he has to give a report to the court.
Okay. Hi, that's the last order.
Yes, Lordship.
Okay. In the meantime, if the report is available, then we'll for the time being we are passing it over. If this report is not available, then we'll adjourn it.
Lordship, can he adjourn this matter for a week? Report is not available. He was honored to start the court.
Okay. After a week, give a date.
That's for minor confusion.
You can fix it on 13th or 15th. When? 13th. It's also is a duly represented. The fair made by Mrs. Gandhi Borana commented today. List on matters and judge today. List on 13/9/2023. 13th. You want 15th?
Lordship, 15 or 13.
13th. We fix it 13th. It's okay.
For admission, item number 6. Item number 6.
You have to get this documents verified through your superintendent of police border. You have sent it.
Lordship, in this matter, we have sent, but we have not received.
Because he has filed this land purchase documents. No, this land documents you have filed or not filed? No, not filed, I think. On 68, I was taken intending to produce land documents.
By us, Lordship, I did.
No, by the petitioner. They are not filed.
It's 20% time, Lordship.
Also, it's represented. The Ghana Council for the petitioner is referred to order dated 68/2023 at 6. How much time? Not for the timing. If you are not filed, what is the fun in taking up matters? then we reject your prayer if you are passing for the time being. We'll adjourn it for the time being. But then the order dated 16/8 giving you liberty to file additional documents will be recalled. You can't play with the court. If you have filed it, then you move it. Otherwise, you take consequences of the adjournment. What do you want?
Any sort of
Okay. Six, 2 weeks time to produce the same. So understand the job. They started with this. In our times, the first job was when I was growing up as a junior. The first thing was to look at the court file, see for what it has come, and then only we should address the court. I never remembered that. That is how we are groomed up. We never moved the court without looking at the file, without the records. Because this situation never came when we were practicing. You all practice like what you call. You are all senior advocates. You don't have to read the file. You just come and stand up and then say anything to the court. This thing we never did. You ask Ms. Verma or any other who are of our time contemporaries.
This is the last chance. That is of 2017 also.
Yes, item 7. Yes. You have not produced the documents. You took price adjournment.
Send a letter advice to but it's confirmed that is not found. Nothing on where now the states are reached. Showing the honorable court's last order in the letter. And the postman address is not found.
Mr. SSS Rahman, counsel for the petitioner, has submitted that annexing the last order of this court dated 16/8/2023, a notice has been sent. A notice was sent to the petitioner. The same is returned back with postal endorsement. Address is not found. Under such circumstances, the court is inclined to adjourn the matter today. In further 2 weeks' time to the counsel for the petitioner.
SP may be directed to
Yes,
And the documents referred to
because he's enjoying a stream.
and it's not,
he may be arrested now.
order dated 16/8, no, sorry, 15/5/2023. Accordingly, the court is also inclined to direct the SP model to Nagarjuna. Nova to locate the petitioner who is on bail pursuant to order dated 22/11/2017. And send a report to the Government Council for the SP border.
Copy of this order.
Take the MSA Verma and standing counsel for the SP border is permitted to send a downloaded copy of this order to the Superior Police. No, Superior Border.
This application.
List of the tools. Written.
Only my lord come to Kerala.
I don't know. We can't go on the basis of hypothesis. Take back your letter.
Question number 8.
FSL report is available.
It has been signed township, FSC report is.
You have the register with you, no?
It's the forensic at the moment. It was produced before this court and data sent to CID and then to FSL. Opinion dated 5/8/2023, second page document. Serial 2 says the last line.
No, you see, this paragraph 2,
Yes, Lordship.
it says examination of the writings in red enclosed part marked Q1 shows differences in tint and luster of ink vis-a-vis so-and-so and tint and luster. So it is only the change in the tint and luster. Now, it doesn't say that the signature doesn't or these do not match. Luminescence effect of the ink used.
The signature has been said again the first page. The first page, submission of status report. The second page it says Lordship. Now I have collected the specimen signature of the accused person and sent it to the FSL to ascertain whether the writings in the attendance register was made by him or not.
It is the opinion writing is not there.
Just complete.
Because this is something we also do every day, especially if it comes to me. I'm not speaking of the bench of my sister. You see, let us say that there is a 10 page of our order, out of which 6 pages are okay, but 4 requires some retype. By the time I am looking at the pages, if the pages are okay, I keep signing and going. So these 4 pages, the order sheets are changed because of the corrections which are made. I would not earmark this pen for second signature. So it is quite possible that my second signature on the other 4 pages would be of a different ink. So it is just the, what do you call the, here it says that it's just the,
Ink used is different.
yes, luminescence effect of the ink used is different.
And signatures are not written with
One and the same.
Maybe what Lordship is suggesting. Once this FSL report comes, Lordship, we can produce the register again with the register.
What is the original? Let's have a look at it. Also, that we represented the this as code, the government advocate has produced a status report from the sub-inspector. This is SIP, Service of Police, Sub-Inspector of Police for Kirigan PS, along with opinion by the scientific copy of the opinion of the scientific officer, Director of Forensic Science Assam, dated 5/8/2023, and a copy of communication dated 8/8/2023 from the same from the Director cum Chemical Examiner to the Government of Assam, Directorate of Forensic Science Assam. The copy of this report is written as a part of the report. Next, government advocate is for us granted 2 weeks time to produce the
3 weeks.
3 weeks. This one 3 weeks time to produce the original register which was sent for forensic examination. Next, government is permitted to send a downloaded copy of this order to the authorities to for production of the school register, original school register. List of things.
Actually, they are declaring for education department objects.
Okay, as education department, that standing council for education department. Okay.
Number 9.
You have the original of the document which is in your file. Show it to us. Just pass it on. So that Seva,
Here's the admit card also. We have also analyzed the admit card.
so do you have the original one?
This is final.
This is the school certificate. But about that,
Original admit card. Original admit card we have not. We have only furnished photocopy. Very first time we furnished. We furnished it.
so fine. We proceed with the hearing on the basis of this, or you want to file an objection? The additional affidavit file. One of the document, Mr. Siddhar has produced an original. Now, are you ready to have the matter heard on the basis of this document, or you want to file any objection?
File it. Let me file it.
It has to be
Yes.
genuine. Because if these documents are there, it can be remanded back to for re-examination before the tribunal. Because if this is linked with this voter list of 65 and 70, then perhaps Mr. Sundar has made out the case.
Then final section of the. This document is supposed to be issued in 1982. These documents were there in 1982. Why did it not produce?
Maybe they have not produced, but now they have produced. Can citizenship go because just because he has forgotten to? Because Mr. Payne, please come to page 53. That is the finding. Now, at page 51, exhibit 1 is okay. Why exhibit 1 and 2 could not be read with exhibit 3 and 4? These are post 71. It's okay, but if some document is linked with 65 and 70, why 71 document cannot be looked into?
Exhibit 3 is the extract level of 1959.
Because till 3 it is okay, because 3 is rejected because post 71. But if the document is authentic and exhibit 1 and 2 are accepted, these are documents of 1965 and 70, then why 71 document cannot be looked into?
71 is there. What is the exhibit 3? Exhibit 3 is 89. And 89 total is nowhere provides any information that this Artima Kapoor is somewhere related to whose name is there in 1970.
No, Court says, you see in the middle, I have accepted exhibit 3 as proved so far as the admittedly and authenticity are concerned.
Yes, 89 is admitted. 89 one Akima Khatun is there. We admitted. But whether this Akima Khatun is daughter of my lord, it is
Exhibit C6. Exhibit 6.
Exhibit 6 is Jamabund. Exhibit 6 probably they have not from color because these picture matter last part, first part. This exhibit, the exhibit is photocopy and cannot be accepted as admission.
It's a system generated certificate copy. That is the first line on page 52. It's a system generated certificate. So if it's a system generated document, that means the state is giving them a document and the court is the tribunal is rejecting it because it is a photocopy. So then we'll have to direct the chief secretary to issue a hard copy. System generated copies, e-copies and all, everything goes for a 6R. How can a state issue a certified copy which the officers will refuse? Under which provision of Evidence Act? So then we'll have to issue a notice on the state why we should not revert back to old system of issuance of hard copy certified copies like that. If the tribunals are not accepting it, tribunal is also a creature of the state. You see the first line in page 52, exhibit 6 is a system generated certified. That is the first line. The tribunal by recording says it is the system generated copy. And then it is rejected because it is a photocopy.
Six provision is system generated certificate for the Brahmaputra resident of certain 4 areas of land government over the consumer soil. This can be a better soil pertaining to the perpetrators including Umar Ali, son of Hossein Mohammed and from Akima wife and Akima
Mr. Pang, one or two things I may not know. Now please tell me if a certified copy is issued, system generated certified copy is issued. I'm asking you because of my ignorance. Is section 78, what you call the requirement of 78 of the Evidence Act, is there or it vanishes? Evidence Act, I'll give it to you. Ah, 79.
70.
Ah, it,
This will have to be accepted. Section 7. These section 79 is provided.
Then how do you reconcile this first line of Exhibit 6 at page 52 and this summary at page 53?
My prayer is that my submission is that suppose I have obtained a certified certificate, oh my God, it is a computer generated. If I submitted this, submitted the Xerox copy of that, I will have to prove it by making the original. This is the original. And
Why is the if it's a certificate copy, look at 78. Please look at 78. What does it say? Sorry, 77.
77.
77.
Production of certificate.
I'm missing out by one section. Proof of documents by production of certified copies. Such certified copies may be produced as proof of contents of public documents or part of the public documents of which they purport to be copies.
I'm not denying that.
No, you see, because it is fundamental. You see, I come up from a civil background, you must be knowing it. Correct. So in a civil suit, we prove the title by producing a copy of photocopy of the certified copy of the Jama Gandhi. Some certified copy of the not photocopy. Certified copy of Jama Gandhi. That means what I was doing for last 25 years is wrong.
No, I'm exactly saying the same matter. They have submitted the photocopy of the certified copy.
No, but then why the court is? You see, it is your tribunal. It is writing in paragraph 6. It is writing. It is a system-generated certified copy of Jama Gandhi. So either this is wrong. No.
That line is probably wrong.
No. Look at 114 illustration E.
No. Probably the tribunal has completed wrong.
But look at 114E. If you are saying that there is a presumption, it is for the state to rebut it. Illustration E of 114. All judicial and official acts are deemed to be regularly performed.
I have heard him. He is repeatedly saying this is a photocopy, but the judgment tribunal clearly need.
No, you can see that the original is there. You can see the original one. Look at this. Just a moment. 6, 7, 8. So fine. Mr. Siddhar, please come over to this side. This exhibit 6, court has signed it, but down below it has recorded. No, this is the order sheet. In order sheet 6, the what do you call 6-7, first order. Now look at exhibit 6. It is few pages down the line. So the documents are few pages down. Exhibit 6, about 10, 12 pages down. Correct. In the top, the court has signed it, and down below it has said it's a photocopy. Correct. But in the order sheet, there is no reflection. Once the court signs the exhibit, and there is no objection in the order sheet, then what happens? Mr. Pine, I think at your end you'll have to ask for a what do you call, you see, I did not check it in the affidavit, in the evidence on affidavit. What does it say? Is it a photocopy or it's a certified copy? What does it say? Evidence on affidavit. It was not on affidavit. Okay. Oral. No, is the objection recorded, Mr. Pine?
Nothing. Objection.
No, where is that? Where you are reading, Mr. Siddhar? 42. No, shows the vernacular one. Page 44.
I was born in 1912, something wrong in India, 1960. How can you imagine? He was celebrated about 66 years. At Godavari Pata, PAN card is the proof of my year of birth. I am the granddaughter of Imma Mandal and the daughter of Musim Mandal. Father had another wife named Omar Ali Bibi. Father died 50 years ago.
Then what will happen to the because here there is no what do you call,
Night.
no marking of the exhibits. Then it goes against you, Mr. Siddhar. In the examination in chief, if you have not exhibited any document, then what happens?
he got a share of land from my father.
No, that is okay, but no exhibit is introduced here in the examination in chief. Then what
But
happens?
the tribunal will not mark it. Tribunal has marked it.
But tell me the what you call. You tell me how it is proceeded, because I don't know. A document must be introduced in your evidence. If it is not introduced, it goes. Then what is the wrong in that finding?
Whether I have to use.
Well, it's okay.
Tribunal has said.
No, it is okay. No, I understand. But in the examination in chief, you must introduce that piece of exhibit.
Whether in the applicants, whether their steepness, whether steep rule of evidence is not applicable.
No,
I read the document, the prudence has been marked by the tribunal. And the tribunal also used to take the evidence in seat. Tribunal also normally, this tribunal not taking the evidence in seat. That is also a problem.
please elaborate. I'm not following it.
But a tribunal, this tribunal particularly, this tribunal is not taking evidence in seat.
No, but this is examination in chief.
Examination
Page
is-
42 is examination in chief.
Yes.
Page 44
But
is examination in chief.
But the record shows that it was produced to the tribunal and tribunal had marked it and signed it.
Ms. Verma, take us out from this impasse. Take us out of this impasse.
I will not follow it, I'm asking you where it was stuck.
No, you see, we are got stuck, and it is pretty deep stuck. You see, the tribunal recorded evidence in chief. None of the documents were marked as exhibit in the examination in chief. On 6/7/2018, the tribunal marks that document, despite the fact that it is not introduced in the examination in chief.
On its own.
On its own, it has done it. And down below it has written photocopy. But the first line of this judgment, page 52, exhibit 6, it says it is a system generated certificate of Jamandi. It should have been certified copy because it's not a certificate. But then in page 53, it records that it is a photocopy and rejected.
Contradiction between its own statements.
No, it may be right. We accept that that it is some error on the part of the tribunal. But you see, what is we are intrigued with the fact that we both have seen this. You see, normally in our court proceedings, if a photocopy document is exhibited, it is marked as objection. Because if objection is not marked, that is why we read the order of 6/7/2018. It doesn't record the objection of being a photocopy. Therefore, it is admitted. The witnesses, after acceptance of the evidence, go home. Then they have no business to be in court and then examine whether it was a copy or a photocopy, because objection was not recorded to that particular document when introduced in evidence. And now in the hearing, it is rejected. So then our view is that if it is rejected without being given a notice, then it has to go back and give them a opportunity of,
Even I was thinking since was not marked.
no, it is marked. It is marked, it is exhibited without any objection. But down below, the court also writes photocopy. Now you see that that's what I'm trying to explain it. Normally in a court proceedings, when there is an objection on there is a document which is otherwise inadmissible in evidence or rejected, then it has to be mentioned in the order sheet, because then the petitioner is put to notice that look here, your document is not unacceptable. So therefore, it could have been rectified. But then in the judgment, without any objection, if the document is rejected in judgment, then where is the remedy? She would have got a chance to produce a document if it is the sole ground, because 65, 70, she proves the legacy. Link document is the Javandi. So otherwise, everything is okay, save and except that it became a photocopy.
On this ground, should we demand the matter back with this observation and let the tribunal reappreciate the option?
By giving an opportunity.
Yes. So what we find this fault in many more opinions also, because as Logic has explained, now I have seen in other opinions, this continuous logic.
So is there any precedent where this is accepted and the contention of the petitioner is rejected? Is there any precedence? Well, then we can't go beyond precedence.
Let him iterate this the next week. And some issues are there. Because first of all, whether the documents which has not been introduced in evidence in the SIP can be accepted in that issue.
That question was never raised by the state.
Secondly, whether this issue has been settled prior to this. Similar issues were there, whether funds.
Heard. Mr. A.R. Siddhar Lalit, counsel for the petitioner. Mr. J. Payag Lalit, standing counsel for the FTC. Ms. A. Verma Lalit, standing counsel for the. Also from the same thing. Ms. J. Devi, Lalit, your CGC, appearing as CGC. Arkady Chaudhary. Appearing on behalf of Mr. Arkady Chaudhary and TSGA, Ms. AI Ali, young standing counsel for Election Commission of India. Next paragraph. On examination of the materials on record, it appears that no exhibits are found referred in the examination in chief of DW1. Which was recorded on, what is the date? 6/7/2019. Nonetheless, as per the LCR, seven documents have been marked as exhibits. Only 7. First of all, it is noticed that the Learned Foreigners Tribunal, number 11th, TH 11th, Propeta, Sobho, had marked exhibits, had marked the copy of Javamandi as Exhibit 6 on 6/7/2019. But by another endorsement of 6/7/2019, the said document is marked as photocopy. First one. On a perusal of the order dated 6/7/2019, it is noted that there is no that is not reflected in the said order that Exhibit 6 was a photocopy. Therefore, it appears that the petitioner was not put to notice that Exhibit 6 was a photocopy. Full stop. On a perusal of the impugned opinion, as against dated 17/9/2019, as against Exhibit 6, it is noted as follows: page 52, last one. Exhibit 6, last one, page 52. However, Exhibit 6 was rejected on the ground that it was a photocopy. Therefore, it appears that the Exhibit 6 produced by the petitioner was rejected on the ground that it was a photocopy without any objection being recorded in the order dated 6/7/2019. Therefore, the petitioner appears to have not got an opportunity of rectifying the error which is correct while exhibiting a photocopy. Next. At this juncture, the London standing counsel for the FTC raised for concern to examine the case was as to whether there is precedence of this precedence of the court of rejecting such photocopy document, admissibility of such photocopy document. Accordingly, matters is adjourned list when? Just after a week.
Item number 11.
Association may not have an order that we get responded to file an affidavit. Verifying the position.
Doctor, I have received the instruction.
But you know what has happened? Come to page 91. This is your own document. Page 91, column number 4. It says we applied for grade 3. Correct. Now then, come to page 63. Para 12.
I had applied for grade 4, my lord.
No, it's okay. But that's why I'm showing
They
you.
consider for grade 3.
No, it's okay. But that's why I'm showing you page 63.
Yes, my lord.
Para 12. Now you are also insisting that you applied for grade 3.
My application, the first application.
I've seen that. But you see, your insistence is on grade 3 because now you are again justifying that there are grade 4, grade 3 posts available, and therefore you should be considered for against that post. And the state's stand is that it needs a BSc, which you are not. So it is your own representation which shows that you have applied as in grade 3 instead of grade 4.
That is the reason why they were directed to file an affidavit clarifying the position.
Lordship, I have received the instruction.
Let them receive no affidavit, my lord.
Lordship, let me submit. Lordship, as per my instruction, if you go by the petition application, he did not mention any post.
I mentioned, my lord.
Lordship,
Page
but the
77.
present
No, no,
comment,
no, no.
you submit qualified
That,
executive
no, no,
engineer.
that cannot be correct. He applied for grade 3 and grade 4 both. There's some document which shows that he applied for grade 4, page 26.
The representative.
Soturto.
Page 78.
26, page number 26.
Soturto.
But as per the format that has been submitted by the executive
But that is a
engineer,
mistake of the
yes, for the
authorities.
department. That's why we have considered his case. The DS is considered for grade 3, because there is also vacancy for grade 3 post. So we have considered this case. in the
Your
grade
officer unfortunately could not read SMS.
for the prescribed format. Myself.
So state, what do you call, the emphasis on the state language falls apart. I have started to learn and read SMEs, but your officers, they are wrongly reading Soturta as grade 3.
Grade 4.
But sending back will not help us. You have to tell us which year vacancy they will be considering. Because he died in 2009, right? Or 13? 2013. 2013 he died. So vacancy will only be 13-14. 13-14 vacancy will not be there. The amount of what you call compassionate appointment cases we are taking up, I don't think 2009 somebody would have omitted. Then what is the fun in sending it back when we know it is sure to be rejected? So account for that reason we can't give you any relief.
There is one minute later, place it on affidavit, my lord. I also want to see what they are.
Okay. You have an affidavit. Gets a lifeline. Also, it's a video presented. This and the
So many years back that compassionate.
no, but it's a he has taken a good ground. It's a legal right. So even if that is there, legal ground is available. He applied for grade 4. Your officers converted into grade 3 and therefore ousted him. But that will be legal malice in law. Rather, we can bracket it as a malice in law. It may have been a mistake. It may be bracketed as malice in law. Government application. Submit that she has received instructions and please for some more time to file affidavit in compliance with the order dated 24/7/2023. 2 weeks.
My lord.
List after 2 weeks, the affidavit shall be filed at least 2 days prior to the next request.
Okay.
We are returning back the
My
instructions.
lord. Problem.
Yes, item 12.
Well,
Just. Yes,
It's not that-
fish follows water. So, consume some water and now we'll see how fish follows it.
It's also involved with water. It's also involved with water.
That's why
But I've already filed the format. My name is not-
no, it's okay. We are not questioning that. Learned council is there. I'm not questioning.
But this is the case, it's a 60% rest fishery. It was given to me to lease for 7 years. And that period will have ended from 2013 to 2000.
With the change in council, with your petitioner get adequate protection from illegal encroachers, illegal catching of fish. Do you supply musclemen also? No. Then, at best you can exercise your right to claim a what you call remission. But why it can be a ground to what you call allow your prayer.
Only because the worship looks at the first the worship can look at the page 31.
31.
Yes. This order was passed by the authority after upon perusal or direction of this honorable court.
Yes.
I came before this honorable court for a extension. But not only one thing before I go to that, I will just I'll take only 1 minute to summarize the thing. But it was in the period October 2020. If the worship recollects, then this COVID-19 started from the month of March and the lockdown and everything from 2020. So we, during that period, during the lockdown period, when they knowing that we could not fish, we went for this extension. And ultimately, the department gave us the extension for 2 years.
No, you see, a bit we can go a bit behind. You were settled in 2013.
Yes. For
So
7 years.
after 13, it expired 7 years, 2020. Then again 2 years. Correct. So now at the end of the 2 years, now you are saying that you could not catch fish, somebody was encroaching somebody did not allow you to fish.
That encroaching and everything was in the report of 2017. Considering that 2017 report and everything, they gave us the extension. But only thing, my lord, if your lordship recollects, this extension period of 2 years, from 2020 to 21, almost 1 year, 1 month. It was in the lockdown period itself. So then we approached the Honorable Court. This Honorable Court observed that if there is an exceptional case made out, then please you do the needful. Then there was a hearing. The hearing, this Honorable Court's order was, my lord, 26/10/2022.
Yes.
And then hearing took place on 26/6/2023. And 4/7, the order was passed, page 31. I will not trouble much because I know my position. But only
Your
page
position is
32.
strong. Every fishery is in a very strong position. That is why they litigate so much.
But what happened because of this?
No, it's a good ground for emission. But you see, it can't be a ground to stop the tender process.
No, I'm not against the tender process. I'm
Then,
making it clear, man.
okay, then
Then, my lord, if the lordship comes to page 32. My lord, order starts from page 31.
$31.
Page it starts from 31, my lord. And my lord, the first paragraph of this order, the lordship will say the matter relating to the extension of lease of so and so. District in the light of the order of this honorable court order so and so 26/10/2022. Where this honorable court said, if you find it exceptional ground, you can do the review. So this order was passed. By this order, actually, my extension was rejected. So what they have observed, my lord, page 32. When first Roman 3, your worship got it.
Yes.
What my lord is saying like, regarding the remission, my only thing was that, my lord, I could not pay that because of this problem and derailing the entire business because of the COVID and car. So I was 10,000 in debt, and ultimately I will become a defaulter, 10 lakhs. I will become a defaulter in the next process. I will not be able to participate. So this was observed in 3.
You have to deposit.
Yes. My lord, now see the next 2, 1 and 2, my lord. DC Nanga will take steps for fresh settlement of the fishery at the earliest with the issue of NIT with reassessment of the revenue. That is because of the encroachment and all this one area because of the cement factory and polluted water and all this. My lord. My lord, second is in the meantime.
You are responding for Mr. Sharma. You are enjoying the fishery right now.
No, by the time.
The fishery is
Oh, you are for the government. I'm sorry.
no, I am fishery.
I'm sorry.
Fishery.
Okay.
My lord, second,
Mr. Sharma, why can't we fix a direction? Because here the player, you see, come to the player in the repetition. It is at page 54.
that is the repetition of the other second, not mine.
Okay, then. Okay.
As long as it is the order.
Where is your repetition?
And Villain was the respondent in the report.
Where is your repetition?
My repetition. No, my repetition is not here. I've come, but against this government order, which I have just made your worship aware of. This was challenged before this honorable court
Yes.
by somebody else.
Okay.
And then the honorable court passed the order. So I've come against the order now. So before going to the order of this honorable court, I have just come to the order of the government.
Okay.
My lord, would your lordship be pleased to see page 32, that second observation, my lord, last observation. That is my case. My lord.
Just a minute. Yes. Yes.
My lord, to clarify, it is a reputation filed by X, my lord, against me.
Okay.
In fact, this order which I just placed before my lord.
Yes.
And my lord, especially the second part, this is page 32.
Yes.
And my lord, this is my case only. In the meantime, till the process of next regular settlement is completed, the petitioner society may be allowed to run the fishery in terms of the earlier order so dated so, during which period they should recoup the amount against outstanding dues and deposit accordingly.
Yes.
Against this, my lord, acts came before this honorable court, and this order, which now imbued in this writ has been filed, has been passed, my lord, and it is in the motion stage without any opportunity to me. I was there as a caveat, but I did not get further opportunity to face anything. But whatever it is, this order is that now is before my lord. My lord, the only, without going into this entire detailed order, my lord, I can go to page 22A.
Yes.
Therefore, this is the operative part. Page 22A, my lord,
22A.
22A. However, this improved order automatically comes after the memo of appeal. That is the reason you have to reverse.
It's okay.
Page 22A. My lord, second word, therefore. This is the operative part.
Yes.
Therefore, it is further observed that the respondent number 4 society shall, that is me, shall not be allowed to run the fishery beyond a period of 1 month from today, that is beyond 13/9/2023. Next part is another. In case the process of reassessment of revenue of fishery is not complete within a period of 1 month from today due to any exceptional reason beyond the control of the state respondents, the state respondents shall run the fishery by themselves on and from 14/9/2023 till the completion of the competitive bidding process initiated by publication of the NIT as directed. I am against this statement. The government, while passing the order, they took note of that and they gave me this opportunity till the reassessment and the resettlement. I should continue in order to cope up with that outstanding amount. My lord, behind the back of the one thing, you have to imagine the scenario. These people are, my lord, fishermen, the lowest strata of the society, my lord. And everything is derailed because of the natural calamities like COVID-19 and car. And because of that, they could not cope up with these outstanding dues. Well, one thing, how can the department run by themselves? They have to hire some people. At least over there, I'm going to pay the outstanding amount. And it's also the amount given per year. That amount is also has to be given. Outstanding amount plus the amount which I'm going to operate that period. It's not that only outstanding amount I'm not going to pay anything. Suppose it is 1 month, I have to pay for 1 month as the rate today, plus my outstanding amount. So what's the
But in
authority?
this, no, but you have been allowed to run for 2 months.
1 month.
No, from July to
No,
September.
another thing the lordship is aware, I don't know. My lord, for 3 months, you can't do any pisciculture practice. Because of the pisciculture planning, you can't do any kind of fishing in the months of May, June, July. This is the breeding season and all these things.
No, that's okay.
Okay.
But you see this impugn order
This one,
in the previous rate petition, that is the settlement order
this one,
at page 33.
this one,
This is an order which I find is of 4th July.
this one.
So today we are in September.
One of this 4th July where there was a ban in fishing.
It's
They have
okay.
passed the order. They have to
So
pass the order, but
you have enjoyed the fishery from when to when?
from the August I started. From the August I started this artificial bund because in order to do the fishing, you have to do certain kind of a work in the river, my lord. And because of that, it takes time. It takes about at least 1 month to create the artificial bunds in order to do the fishing. According to the order, till the next settlement, your lordship may give them the direction to settle within so and so. But till then, I may be allowed to continue. Another thing, my lord, taking the hypothetical view, it is not possible for them to do the fishing. What my lord has, my single judge has said, they have to hire some people. And where I am doing it as an existing lessee, and I could not complete I did, so in writing I completed the term, but practically my lord is aware that it was not possible for me to do the fishing, and everything was delayed because of this COVID-19 matter. And that suffered almost 2 years now. And this order was passed after hearing all the parties. I'm not against the settlement process, my lord. What I'm saying, I may take undertaking before this honorable court as on date. The day settlement is issued, that day I will vacate the area. But till the settlement order is issued, allow me to continue, my lord. This is my humble prayer. Now it's a question of survival of this fishermen. It's not that they have the corporate or anything like that.
Yes.
Lordship, appellate handled the fishery for 7 years. Then my lord,
But what is it?
By
From
way
you,
of
I am interested
extension-
only to know what is the present status of that tender process. At what stage it is there?
that I will have to take instruction.
Get the information at 2
But
o'clock.
Lordship, you kindly see the period.
No, it's okay. That we have taken note.
But
By-
after expiry of the extended period also, my lord, they enjoy for 11 months till today, my lord.
It's okay. But
My lord,
from you, we
about
are only interested to know the
7
present
plus
status
2
of.
plus 1.
It's okay. But from you, we are want to know the status of the tender process. At 2 o'clock, you tell us.
My lord, till my lord 2014, my lord, 14th of this month, they will allowed to continue. In the same circumstances, may I pray your lordship on Monday, my lord?
Monday.
Monday, because they are operating till 13th of this month. They are allowed to operate.
But try to get the information at 2 o'clock as to the on Monday.
My lord, let it be at 2 o'clock the information regarding the present status. Because
Okay, the additional information says that it's time to Monday.
but I thought my friend will support me, my lord, because I was defending their order. I'm surprised that my friend is
No,
against
he's not
me.
saying anything. He's
No,
not
but
disclosed his.
it's a question of he's
Supporting
enjoyed and
and
all these
objecting
things.
is-
not
No,
disclosing
but
anything.
I am in order to survive
And-
their order.
No. And Mr. Abedin, where did you get the idea that someone standing to oppose you will be your friend? He can be your brother. That I can
I
accept.
understand. But my
It is
lord,
only the brothers who fight.
my lord, sometimes it is very cunning where we make more dependence over the civil. I thought in that manner, my lord.
He's an adversary. He may be your brother. But that is what I say. Amongst the lawyers, it is only the brothers who fight.
Actually, before handing the appeal, we approached the other side who appeared before the honorable court with the petition. But they declined to take the copy, saying that the brief has been taken away from them.
Correct.
So I wanted that matter to be in front of them so that sometimes it is easier to take the decision in front of them.
Okay, Monday then.
You know, honorable court, my lord, takes a deadline to my lord 30. So, my lord,
It's okay, but
But that part
that
is,
instruction I will.
but that part is
What is
only
the stage?
under challenge for this division bench.
What is the stage, my lord, deputy commissioner?
Mr. J. Abedin, that comes to the appellant, as well as Mr. D. Sharma. Your additional advocate, additional advocate, doing for the
My lord, additional senior government.
additional senior government advocate, getting correspondent numbers
My lord, 2 to 4.
2 to 4. Next one. At the outset, the court query to the Learned additional senior government advocate is whether is to apprise the court about the present status of the tender process. Accordingly, the matter stands deferred today. list on 11/9/2023.
Tender process oblique reassessment.
Tender process oblique
Oblique reassessment.
reassessment.
Reassessment of rent.
Reassessment of revenue of that fishery. Because of
Reassessment,
the area has
not
become
just say, and or reassessment of
revenue. In
revenue
respect of
of,
that fishery.
in respect of the fishery in question.
Allot Monday,
11th.
50 of us.
Yes, Mr. Roy.
There is restriction of 150 minutes. There is increase after 1 year.
After a week. Also as a duly represented. Mrs. J. Pang, that standing list for the foreign tribal,
Matters.
huh?
Foreign travel matters.
Foreign tribal matters. Place for some more time to comply with the order dated 1/8/2023. Next for list after a week. Yes,
Yes, Lordship, on the last day, the court was very clear that the other side will be coming up with an instruction. But before that, let me give you an opportunity so that that picture will be clear.
we will give you when we hear the matter. Both sides are ready for hearing, then we hear you. Otherwise, no
Yes,
point.
yes, I am ready for the hearing.
I got the instruction. In fact, for this, we have also given the CCTV footage in the pen drive. CCTV footage in the pen drive, we have given. But I find that particular format is not supporting our computer. I not go through it. I have asked one of their person just to settle that. The footage they have given in the pen drive, but I'm not in a position to restore that because of the format of that particular video.
We'll take it up tomorrow then.
No, your Lordship may take it up tomorrow, but let me make a preparation very
No. Well, you see, do you expect that I will retain everything tomorrow when I take up the matters? I am not retaining anything in my mind. I am not burdening myself. If I am hearing it, then I'll hear it. But to hear it piecemeal, what does it? How does it give me any benefit? Tell me, how does it benefit us to hear your story?
But your Lordship, each and every day the women's bringing and taking the long times are nothing and causing me a prejudice to this matter. And where the Supreme Court is very much clear that pertaining to this such kind of offences, the court should not be at par.
So you want us to look at the video which is not compatible to their system.
That video is relating to something that I will
So
come.
you make a submission, then you are omitting your what you call. You will not refer to it, and you take the consequences of whatever as we will take.
Your Lordship, the CCTV footage are important. I'm not saying that. But before coming to the CCTV footage, there are also other consequences that are required to be considered.
So we have filed an affidavit of petition in the matter. Against that, the petitioner has filed a reply. In the reply, some allegations have been brought. To that matter, we were directed to copy instruction, and that instruction has come. I have placed it. And this CCTV footage is not. I'm not in a position because that format is not supporting my system. That will be that I'll be quite.
Your Lordship, the CCTV footage what the other side is talking about is regarding page 33. Whereas the other allegations that were being overlooked.
No, how should
No. You just tell me one thing. Are you taking a stand that you will not refer to the CCTV footage and permit us to go and we take whatever view we want?
Your Lordship, that is what I say. CCTV footage is important. I'm not questioning that.
Then
But
you
before
expect,
coming-
no, then you expect the same bench to be reconstituted every day to take up your matter on day-to-day basis?
Based on this importance, that may be required. Because your Lordship,
Then we are not doing it, because I propose to hear the matter at one go. I'm not hearing it part-head. I'm not keeping matters part-head and then hearing it piecemeal basis. That's something we will not do.
but based on the seriousness, your Lordship, if the question is so objective, then I declare it comments.
We are giving an option. You say yes and we proceed. We'll hear it right now.
I'm ready to argue.
Then you proceed, you make a statement on from your own, you gave a statement from your mouth that you will not be referring to CCTV footage and we are permitted to take any stand. We take our own decision on that matter.
But your Lordship, that is impossible. That is what
Then
I'm saying.
please don't waste the time of the court. You see, you forget us. You forget that we are on the bench. You turn around and ask all the lawyers whether this is the process in which they will be hearing it. Just turn around and ask your lawyers, the bench is full today. You ask anyone who is interested in arguing the matter without the court coming to a logical conclusion, the matter coming to a logical conclusion. You think our time is so free that we keep all others sitting here and we hear your part of the story and then tomorrow hear another part of the story.
I'm
And this is how-
not questioning or I'm not wasting the time of the. What I'm saying is, if your Lordship permits, and if they come up with an which is an appropriate format of the CCTV footage, that can be taken up tomorrow also. But what I'm saying is, the main contention why this petition is before the court.
We are
That's
aware
not
of that
only-
much. We are aware of that much. Don't think we have not read the file and we have not come without reading the file. So please don't take that chance that we have not read it. Correct? And as sitting in the single bench, I have taken your matter earlier also. Same matter. So don't be under an imagination that we are not aware of what the contents are. If you allow us to proceed, we proceed the hearing. The time which is being taken to just to adjourn the matter, in that matter, I could have heard you. You take a stand that you are foregoing your right to look at your what do you call, foregoing this you exempt this court from looking at the CCTV footage and you please continue with your hearing.
That is what I'm not saying.
Then do it tomorrow. If he says that it's not there, at times even our system may not open this the CCTV footage. If you want us to go through it, then we have to give them an opportunity. He has him the pen drive. He's saying that he could not go through it. That much of faith we have on the lawyers. Otherwise, the system will not work. And if we don't repose faith on the learned counsel, who is the officer of the court, can we proceed with hearing on any of the matter? You turn around and ask a learned counsel, we'll be out for 5 minutes, we'll take a break and come back. We'll take a rest. And in the meantime, you ask your the learned members of the bar, if if they all approve that this is how the court should proceed with the hearing, we'll take it up. We go by the vote.
So that's not required. But at the same time, if your Lordship.
No, you see,
you have one-
what more transparency we can give? We have put the matter to vote.
Yes. No,
The learned counsel may vote and then tell us that you proceed with the hearing, we'll take it up. What else we can do?
so that is what I'm saying, that if your Lordship take up this matter tomorrow, then as a fixed right.
That's what we are saying. It could have been done 5 minutes back. Both sides that we did, petition in person and Mr. Tina, additionally, the learned senior government advocate, submits that he has produced the instructions received. Mr. Our comment is submitted that insofar as the CC footage is concerned, he has it in his pen drive, but it is in a format in which it cannot be opened in his computer, and therefore he submits that he could not go through the CCTV footage for his own satisfaction before addressing the court. So he has also submitted that he has called the departmental authorities to assist him in opening and viewing the CCTV footage. Accordingly, he pays for a shortage on next. There is allowed list on tomorrow.
And one more prayer, Your Lordship, because this repetition consisting of various other things which always are not required to be argued in an open court. So that is why if Your Lordship just permits for a chamber hearing tomorrow, if they come up with a proper.
No, chamber hearing will not do. You give a written note, we'll take note of that. We'll take it as a camera hearing, but we will not retire in the chambers and hear matters which are there. If you have anything which you think should not be disclosed, you give it in a written format. We'll take it into consideration. We will not divulge in the open court. But chamber hearing,
Then it's fine.
chamber hearing we are not doing.
Then it's
We
fine.
accept
Open court only.
what has happened here. We have taken note of that, but we permit you to file a written argument, and we can assure you that those will not be divulged in the court. We did not have to refer and repeat it. I can assure you that much. You can do so. We permit you that. You want us to record in the order?
No, not required.
No,
I
still,
will.
no, still
I will
we
take it
give
up
you.
to argue in the open.
No, it's okay.
No,
We are not embarrassing you. It's not a question when you feel that you may be embarrassed.
no,
we can take-
not a big deal. I will open the, I will argue with the open.
Written what we do. We'll still permit you. The petitioning person submits that there may be certain contents in course of hearing which may embarrass her to be addressed in the open court, and therefore pays for a chamber hearing. First, at this stage, we are not inclined to allow a chamber hearing. First, nonetheless, if the petitioning person feels that there may be any submissions which we tend to embarrass her, the court permits the petitioning person to give a written note which will be kept by the court in seal cover without disclosing it in the open court, so as to protect and respect her privacy. This one, we permit you that because we know there may be things you may not like to hear.
The prayer I made because in the last.
I'm not
edition
wait,
also,
because
the
I've seen your
the
FIR.
Other division bench also took the chapter.
I've seen your what you call this contents of your FIR. Therefore, I'm with you, but I prefer a open court hearing.
Supplementary holiday, item number 26.
Lordship, can the matter be taken at food as my senior is in food number 20?
Oh no, this matter I have not been taking up. I'll be recusing myself in this case. With this man, I have what do you call it? Petitioner. I know the person, so I'm recusing myself. He was the law officer in the. He was the manager in the Industrial Cooperative Bank.
Yes.
At that point of time, I was heading to the bank and as a lawyer, and he was the instructing. I may not like to take up this. This matter before. What says it? This matter before any other bench without one of us. Case. You have urgency in the matter?
No problem. Next year, because matters are remanded back to the court.
Mr. Edas, Senior Counsel for the petition, please submit that there's some emergency matter based on 11/9, 13/9/2023. Okay. Yes.
My Lord, recommend on the last, I will inform my relevant staff. Issue the notice for when the matter was before the single basis. But there was my house.
No, it's not the order appealed against whatever the appeal order is not passed by this court, by this bench.
I mean, that is the matter will take it after some time.
After some time. Because in a writ petition, let us say in a given case, 10 honorable judges take up the matter. So in a writ appeal, will all the 10 honorable judges recuse themselves? If it's not the impugn order, then I'm not affected by it. It doesn't matter.
What's it be taken after 2 o'clock?
2 o'clock. Okay.
After 2 o'clock.
Oh, yeah, number 16.
This is ordered in 9/5. It's not,
But you did not file any document. So we proceed.
We have Boardman. We have Boardman, we have informed that they were some, they are like, I did the issue.
So I give you a last opportunity because this is a hearing matter.
Yes.
Both sides are duly represented. The prayer made by Mr. Yes, also to the petitioner. One last opportunity of a week is granted to file documents. And in terms of order dated 9/5/2023. After some time, you just tell Mr. Das and come.
Again,
18 also, same. Okay. You tell Mrs. Rapp and then come.
starting from outside, you will not fix a date in November.
No. After some time. After some time. We are taking up.
20.
Says
20 and 23 also after some time.
20 and 23. Okay.
21.
So Rajita was here. Okay, pass out the brandy.
Thank you, Your Lordships.
At the bottom of your coat. Yes. Yes.
Essentially, a PI. Maybe the third or fourth, to file the other stakeholders.
Yes.
Lordship will kindly see, we have, in the petition itself, we have filed out the essential issues that calls for education. If this matter was heard at some length, the previous location. Please Lordship should kindly see para 2
Of the repetition.
of the synopsis.
Synopsis.
We have filed out the issues that calls for determination. That should be, I think, so page 2 of the synopsis.
Yes.
There is big paragraph.
Yes.
The petition has been filed because certain issues relating to the rights of the borrowers, which are recognized and guaranteed by the court, as well as by constitution and now in some economy. This has been done by executive orders, which directly
Just a moment. Yes. It was. Yes. Yes.
And just directly. Prior to the certain issues related to the rights of borrowers, which are recognized and directly by this accord, as well as constitution and now been subject taken away. This has been done by existing orders, which directly and substantially against the rights of the people and is contrary to the law laid down by Honorable Court, Lai Sahib, that fundamental rights cannot be taken away by executive orders alone. In particular, in this case, the rights of constitutional autonomy and the culture are violated in contrary to the provision of the Chief Schedule of the Constitution and the Second Boer Accord signed in 2003. From the attending facts, it does transpire that such rights which inhere in the Borough people and in the Borough territories are being gradually filled, and to take away the very autonomy which was guaranteed by the Second Boer Accord and the constitutional dispensation. Certain offending clauses of the tripartite memorandum of settlement, Third Boer Accord, signed on 27 January, is also being accepted. These are expected hearing for ready reference. I'll take caution to this, but we have just extracted the clauses that we are stating here. And it also will come para E of the paragraph. There are a series of notifications which have an deleterious effect on even what was guaranteed by the Second Boer Accord. This has been done in the following manner. A separate notification dated 28/9/2020 has been issued, by which a committee is constituted under para 14 of the section of the Constitution for alteration of area of the BKT areas in persons of clause 3(1) of the MOS dated 27/1/2010. By the separate notification dated 28/9/2020, the name BPAD as specified part 1 of the technical appended to para 20 has been changed to BP Boardman Territorial Region. Notification number AA so and so dated 19/1/2021 has been issued, whereby the services of the deputy commissioners in BPAD were partially placed with the Boardman Territorial Council in respect of all development activities in their respective districts, with regard to the responsibilities assigned to them by the Ministry Authority. Order number so and so dated 4/6/2021 has been issued by which the Deputy Commissioner of the Board of Land Territory Division, that is, Deputy Commissioner of Kokrajaya, Silang, Basra, and Udaipur, were entrusted with overall monitoring and supervision of schemes pertaining to 15 subjects entrusted with the PTC. Notification number so and so dated 10/6/2021 has been issued, creating a new administrative department named the Welfare of Board and Department in immediate effect. Thus, from the facts above, it would be apparent that the entire object of accepting the unique identity and culture of the Borough and Borough is being constitutionally undermined by the issuance of the aforesaid notification that are contrary to the principles of constitutional jurisprudence. So, we have called out for the benefit of this board the essential issue that calls for determination. Now, Lordship will kindly see here on the last occasion, before I proceed further, after a certain point of hearing, the Lordship will kindly see the last order passed. I'm sorry, the order dated 25/5/2020. On this date, when the matter was substantially heard, that this order was passed. The Boroland Territorial Council was constituted after being granted autonomy persons from the accord dated 10/2023. Considering the scope and tenor of this PIL, this court feels that at a period of nearly 20 years is passed, it would be appropriate to seek information of the following two parameters. Number one, status of major development works undertaken during the period, and second is the recruitments made in the subjects for which the BTC has been given access to. Now, both the parties have filed their affidavits. They are on record. So, like to have this.
No, we have it. You just tell us, we'll refer to it. If you want us to read it, we'll read it.
No, only on that aspect, the affidavits.
Evidence are there.
Yes. Now, one more affidavit will be required by candidates appearing for BTC. BTC's affidavit has not been filed till now.
there will be a specific direction to BTC to file it.
They may not
But
want
they are-
it.
No.
They may
have
not
to-
want it.
They want it also. It's not that they somehow there was some miscommunication. They thought that everything will be done by Assam government. Actually, I represent both BTC as well as state of Assam. State of Assam, we have filed 2 applications. 1% to the order which my lord just.
No, because we see what you are saying.
There is no conflict
No,
otherwise.
not that.
No conflict. BTC are
No, that's okay. What I'm saying is that since Mr. Goswami is coming from auto station, he could have informed him earlier. He could have.
no. It was never heard about. Today,
Okay.
preliminary just the pleadings are not yet complete.
Okay.
It is not completed. Hearing for the not for the purpose of hearing. At the initial stage, that kind of hearing, not a regular hearing.
Okay, I don't know. Since it has come for hearing,
But if he wants to stay, more difficult because it will take substantial time. In the meantime, in 1 week's time, BTC should also file it because it will take some time.
Yes, Mr. Goswami.
I have no objection. What's in a start the hearing? That's okay. Give them
No,
another
no.
part also.
No. Part is something which I'm not doing.
The only thing is that BTC will have to file an affidavit. They will concur with the state government stand, but there should be because
Before I
they are
started,
challenging a tripartite agreement.
because before I started parted, my headline was not so thin as it was earlier. Parted is a disturbance. Mr. Rama, within how much time you will be filing it?
2 weeks.
2 weeks. You give a date so that it's convenient for Mr. Goswami to come. Otherwise, since he's outstation counsel might be.
There is an intervener also here. I will also find my affidavit.
Okay, you're an interviewer. Who are you?
It says allow the university kindly peruse the IN 152 to the.
It's okay. Just tell me who are you?
We are the concerned citizens of government.
Okay. But being an intervener, you have limited rights to argue for the court. You know that. You know the limitations.
Yes, sir.
On 21st of
Mr. Goswami, agreeable?
No, they may intervene, but they may not be allowed any pleading
regarding the date.
Today, but date is subject to lordship, sir.
21st. No, but an intervener will have a right to file an affidavit. He will not have a. His stand he'll have to give it.
His time is already there. The application.
No, that application goes away once it is allowed and it is disposed of. Dispose of application to take up. It's on you if you agree to that, because I find that according to my limited understanding of jurisprudence,
No, you're not allowed.
once an application is closed.
Absolutely right, but one, a right of an impeded party and a right of an intervener is absolutely different. Intervener may have a right to be heard, but heard of the pleadings that are already there. He may not have a right to independently set up a case. If he is impeded as a party, then perhaps that right would be looked.
Yes, Mr. Saiya, what is the law in
The
intervener?
principle is correct. The intervener will have to support either the petition or the respondent. He will have to take a stand.
So without any pleading. So then you know the answer.
Yes. But my name is not recorded.
Huh?
In the first place, my name doesn't come.
Okay, I will take up.
From 20th, there is a CB matter concerning Assam, commencing on 20th of September.
You agree to a date, you just tell us the date, we'll fix it on that date.
9th of October, it is coming.
9th is a Monday, we can also take it up.
No, for the bench, it's the same thing. Monday or Tuesday doesn't,
Fine. Fine, fine, this time.
right?
9th.
Maybe file at least a week before that. Serve
Yes, yes.
the last
Abhisai Goswami, counsel for the petitioners. Just like this, Mr. Goswami, counsel for the petitioner, Mr. D. Sarkar, Advocate General, assisted by Ms. P. Barber, counsel for the instructing counsel, Ms. P. Barber. Just architect of the DSGA, along with Mr. Louis, instructing counsel, as well as Mr. T. Deori, counsel for the intervener are present on the prayer made by Mr. S. R. Raghunath, stand counsel for BDC. The latter stands adjourned to enable him to file affidavit in opposition within 2 weeks. Affidavit in opposition by the on behalf of the BDC shall be filed within the next. Tell us a date within which you will file. it, right? No, date is fixed on 9, but you are filing an affidavit by when? Because they will file
For 1st of October.
1st of October. Okay. Is it
Once
one?
I just said 3rd of October.
No, because he'll have to get some time for respond.
Then Lordship is 29th of September.
29/9/2023. So responsive any filed within 6/10/2023. It's not written by the petitioners. This is the matter for hearing on 9/10/2023. Oh, yes. Before that, you write. The registry shall reflect the name of the city Deori as counsel for the intervenor by registering the meta-analysis.
Item number 21, we are seeking some accommodation.
21. Oh, okay.
It was called,
Yes, they're not there.
I'm sorry.
21.
Can you tell us?
Just from 14, 9/22. That's paid for by Mr. S. Chakravarti, counsel for the appellant. Those are the petitioners. Okay, this respondent is not appearing. Notice is served.
Appeared, my lord. I don't know why his name is not shown. In the earlier order, his presence was there. He appeared here.
So just item 21. You should have informed Mr. Nair today. Please, once we are aware that his name is not there. The registry shall reflect the name of Mr. U.K. Nair, Senior Counsel, along with Ms. S.S. Hazari, counsel for the respondent by listing the matter list. And any other counsel. Along with other counsel. We'll just wait for some time. Let me see if you can add to that. You can add senior counsel. Just wait for some time. Because his Bhagavatam I am not finding. So therefore, his name is there, but
He appeared, my lord.
it's okay, but let it take past his presence. Wait for some time. Or you can find out if this one ad is there. And then Yes.
That there was no justification and demand which was only 6 months from the date of existence of proposal. So now controversy involved in the case with regard to the situation of lake without getting the sanction. Civil Code number 22/2008 is open to the entry directed pending disposal of this petition. The order correct the extent collecting custom. Before maybe correct exact specified
Just a moment. I think we'll need the old book. I'll send the new
Well,
book.
may I hand over a compilation having the relevant portions what are required in this matter of the
Hold, actually, I have, just pass it on.
because the old book at my chamber is no more carrier. So to find it.
Okay.
Debate 26/1992. The prayer for election is ordered directly to the respondent and allowed to debate. Official page for the period from 29/6/1992.
Just a moment, it's okay. Your only case is that your demand is raised within 6 months. That is the only argument you are making.
Ultimately, Honorable Supreme Court decided.
How do you establish that the demand was made and served within 6 months?
The opinion deferred to demand that equal to the refund amount and other papers issued total notice on 24/7/1995. Within the time limit of 6 months from the judgment of non-motion. Supreme Court was judgment on 20th of March 1995. Not March 2. So was notice was issued on 24/7/1995. The date that it was finally decided to
But you come to this page 68. If you're on this, you know. Subpara 9. The present appeal is a consequence of the said demand order passed by the commissioner, hence the question of earlier order, so and so. So therefore, this is not relatable to, this is the impugn order, right? So this was under consideration.
This is the order.
So how about that the demand? That's
What happened in this case? That classification was finally decided by Supreme Court in 1990.
no, I'm following you. That's why I'm asking you a pinpointed question. this order.
It should probably 2013.
This is the appeal is directed against this order.
Not. It is directed against the page 74.
Page 74. Okay, 1 to 17. So then here also you see the first line itself. It starts from the previous line, previous page 76. The fact that the applicant was not paying duty with the effect from 26/7/1989 was very well within the knowledge of the department. So this is
Yesterday, the duty was the and it was 3%. Then ultimately Supreme Court decided the classification.
no. You see, there must be a cutoff date. Once you say that it's a question of the refund which is you are seeking to recover. That is one part. Here is one part of the claim which is otherwise barred by limitation, because this 89 was never a question of refund. So this is a claim which is a what you call original claim being made.
At the time of the case was securities.
No, I understand. You see, so please tell me. So far as our understanding goes, if you have a live demand, then I can understand that because of the Supreme Court judgment that live demand was, you made the demand but it was not paid. So therefore your live demand remains. Now, what I understand from here is that the one part of the claim which you are making is not only for refund, but it also we are seeking to recover duty of a period which is otherwise barred by limitation by 6 months.
We consider simply that it is simply not a time part. The circumstances here, initially it is not spending, then we were restored, then it was modified. Finally,
I'm not. That's why I told you the earlier order. I don't find that this is page 77. The statement made here, 26/7/89. That was stated by any court proceedings. Because then it would be a still claim.
page 76, paragraph 3.
So this was refunded to you. So one part of the claim is okay. No, just a moment. Let him clarify because I'm putting a question to him. I'll come back to you.
Page 76. The appeal is filed against the following original dated 21/2013. The appeal was mentioned the manufacture of Long Code. There was long-standing dispute for the classification of the item as well as utility of the same. The author finally came to settle the Supreme Court of India based on collector versus products. The effects for the proposed manufacture that will be classified as so giving 4.0890 the statement.
You take us to the demand notice of the commissioner on 1/11/2010. No, you see, I'm trying to just understand what you are arguing. Your first submission referring to page 76 was that the duty regarding to 26/7/1989. Now you showed us the what you call the order where this claim has been bifurcated to 2 parts. Para 3, page 76. You're saying it's in 2 parts. Now, this way I was, that was the first question which I asked you. Page 68, you see para 9. This is the contour of the appeal. Appeal was directed against demand of 1/11/2010. So, therefore, I am presuming, since I did not go through that letter, so therefore I am presuming that your demand which is made was a claim which is otherwise time barred. That is my question.
That is the question decided with the tribunal. It's a, that it is that one. What application is there? And the application is pending. So some of what application side was rectified. But therefore, it is 6 months period for issue support.
So where is the judgment of the Supreme Court? Was the respondent a party there?
It was the case from the side of.
No, it may be there,
Yes, I'm-
but you see,
I'm pressing
in a
some-
litigation.
I'm pressing that judgment. We covered more.
No, no. You see, it's a, when you say that the demand was kept pending because of the Supreme Court judgment, then he must be a party to it. Otherwise, the
I'm relying on court judgment like this. I've already.
Oh, acha, one of them. Okay. Okay. Well, you got my point.
Yes, yes.
If it is barred by limitation, then your demand is rightly struck down of
Apparently-
one time.
Apparently, it seems that the demand was tight.
But now you're saying that the Supreme Court judgment, you see, when the original demand was never made against me, which was kept in abeyance. Therefore, that demand is otherwise time barred.
Classification for a particular product. There are also manufacturing and that's also.
I get it. You see, if there is a
Yes, what's the mind? That's all.
the point which I'm trying to ask you is that once there is a valid demand, which is kept in abeyance because of any litigation, then I can understand your point. But if the demand was made in 2010, which is explicitly barred by limitation, then why is this judgment wrong? That is the only question we are asking you.
Yes, court judgment. That's right. That's here and here. But I was finding the color
No, it's not there. Because it's not there. You'll appear on the next date. We ask the registry to show their name. Order is already passed. Santi Sharma. You can have it, Santi Sharma. Okay. Yes.
Currently, this is then there is a demand is time. But since that, since that you will decided to I want to place
Yes. Which page?
this
76. Paragraph 2. Yes.
I think already it was engaged in there was one stringing dispute about the classification the same as well as utility the same. The data finally come to the settled by the Supreme Court. This saw electronic certificate versus products. It was a reason. As it was manufactured by the will be classified but some things don't consider However, the reasons made between period 26 and 9 to 193 won't give you a speech. It is pertinent to record that the Supreme Court passed its final order on 8/3/1995. And to that, the department proceeded by issuing super notice to recover the cellular site which is in the entire period from
there is no justification for placing the separation on the part of that. And under the legislative of the department justified the interim order. It is sufficient. If the assessment during the entire period were provisional. That classification is as partly fair because we are not finally assessed and we are finalized only after the activity of the decision of the tax. Subsequently, the time limit for 6 months is to be calculated only if the final decision is increased. A solution where the demand is given time. The delivery decides on delivery condition will be find that the classification was subject matter of the dispute. The dispute can be finally settled in the issue of the Supreme Court. For the classification is to be made under 4.090 and further while there is no dispute about the dependence of the action after the decision of the apex court, there is dispute between the agreement and the department regarding the assessment is provisional or not. The lower authority what is the finding that the classification is calculated only where we are not finally assessed and the original action going to finalize only to take the Supreme Court decision. And to specify clarify the points, everyone probabilities of such not necessarily followed and others. There was a common order of provision the solution that it is very poor and because of the regulation was leaving aside this obvious that the issue has been running for a long time. It is also obvious that the department was aware of the fact that the exercise was not being treated as a regular.
You have this judgment of Woodcraft products with you.
Yes.
Just see paragraph 1 in the last paragraph.
1995.
The citation.
1995 SSC page 454.
Yes, 454.
So which paragraph of
The first paragraph.
the main question of decision in these appeals and it matters is whether to move and to specify under heading 44.08 subheading 4.0890 as given by the agreement or under the heading of 4.08 subheading 4.10 as given by the manufacturer of the period and will continue to 86. March 1992 to 1992 and from 1 to 1992.
Now come to para 2.
For the first period, the president had the judgment notice
Correct.
15 till
So
19.
only that much. So therefore, I have presumed from this order that number 1, for the period disputed first period, a demand was made and the assessees went to the tribunal. And whatever be. So in this case, did you raise a demand and the assessee had to go to tribunal? No. That was not there. Now you see, if you come to the last paragraph of this order. Yes. Second last in fact. The result is that
The result is that the decision of the tribunal reported in Gujarat and High Court in commercial forest of reverse. While the decision of the High Court, which is 73 third period, from 1392 is reformed. Even though the different reasons
so therefore what happens is that I'm trying to show only things that there was number 1 demand made. People went to the tribunal against the tribunal order High Court and then this group would append the classification. So now, does the period of limitation extend if the revenue does not raise a demand That is the only question which we are confronted.
What was raised? What we have clear classification of the different the duty was given.
And then they will have to show us that the Supreme Court in this order permitted you to raise a demand which was otherwise it's not there. You don't find an infirmity in the order of the tribunal.
My point.
It shows that the decision.
First question. Whether the language was testifying the emphasis on formal order of provisional teachings applied to the resolution made by the Supreme Court case of small influence. Quoted in 1992 supplement 1 3. So 1992 supplement 1 SCC case 293.
Yeah, that's true. Where is that substantial question of law? Which page? Yes, 1912. Yes. Yes. Samrat is the para 9. You have given us a copy of that. Which one is that?
I can share one.
It's okay. You can leave that copy. One copy you will give us. Uh, 1992.
1992. Supplement 1 SCC
Okay.
case 293.
Okay. Yes.
Paragraph. Short form. This is the scheme.
Huh.
This is the scheme for payment of duty of clearance of goods by the manufacturers. This procedure is known as self-removal procedure. There will be no time down for the effect of the speed of the test. A period of 6 months is prescribed. We have already seen section already says in the period of 6 months. This that duty itself is paid business that is like or the And June 385. And this was the two. SSC was clearing the goods by determining itself and putting the amount completely in his personal ledger account. The amount of duty paid by him was obviously provisional and subject to the actual of the personal ledger of the official account. The proceeding prescribed under Rule 9(2) except the circumstances that no document provided in Rule 9(2) is required in case that the personal ledger account is pending on the elements of the books. Since there is always a balance in the account, current sufficient to cover the duty that may be demanded on the books relating to the removed. In these circumstances, the balance of books at the agreement between April or and June 2025 and their accordance with the procedure of the such situation, those who have parity of extension under section 11(2) will be restricted. In this case, the article return from the month of 1985 was filed on May 1985, and the same law says October 29, 1985 is therefore and in the date of this signed by this section has been duly applied. In this case, the refund application is filed on 1985. Now,
So this elements are not there in your case.
was finalizing on 22 March 1985.
No. Basically, I'm finding it in your list of dates. That's what I'm asking you. Number one, did you make a what you call? It's not your case. It is not your pleaded case that any provisional assessment was made. Classifying, so there is not a dispute. And this judgment you are citing, here the assessment was made on 29th and 85. And Supreme Court says that after that, bar under section 11, we will operate. So the same ratio will follow in your case also.
Here, last line. The refund application is filed on October 1985. Amount therefore said to be acquired.
No, the fund is. You see, if I am following you correctly, there is one demand which is which is prior to the date of which calculation was made, and you made the refund. So that is one part. The second part is that of the amount which you have refunded. So claiming of refund, well, for the time being, we take it that it is permissible under this judgment. What about the previous day? Because you are trying to demonstrate that within 6 months of the date of the Supreme Court judgment, you have raised the question of refund with the respondent. So for the first part, I think it's barred by limitation. You cannot save it. Any other citation? Twenty 2022.
2020.
Not 2022. Okay.
173. Many cases the response of only one safety must be correct.
I don't know whether it matches with your Supreme today or not. But this contention was rejected in my Supreme today is 65, para 65. It starts when selection of successful candidates. No, no. You see, the ratio is why it was rejected is in para 65 in Supreme today. It says in para 65, it says, we are not inclined to go into this question in view of the order passed by the High Court dated 4/6/2015. In WPC so-and-so, the High Court asked the petitioners or private respondent lawyers to impede the incumbents and parties who had been selected for the post in question. So therefore, it was not, they were not impeded. Therefore, it says that we are not inclined to go into the question as to non-impeding of the successful candidate in the petition.
Paragraph 67, it starts from considering High Court. Considering High Court, intention in the light of the judicial pronouncement is good. High Court submission is liable to be rejected. Not always company number of witnesses shall be allowed by the High Court. However, the state is to file appeal only in one case, which tends to be allowed by the Supreme Court in the same case. In that situation, this court will review that the decision of this court and all the petitions from the High Court, even though they were not respondents in the appeal for the Supreme Court.
But when in the last paragraph, you find that it was common judgment. In the last paragraph of this, it says it's a common judgment. Here in your case, it's not a common judgment.
Again, for the respondent, this was
So therefore, it's not a common judgment.
this is here.
The issue must be interpreted on the basis of facts on which it is decided.
We have because we have the question import the classification of particular board. It's also the traditional. So
No, it's okay. No difficulty in following you, but the question is that if the petitioner was not put, if the respondent is not put to notice, then 11B, how do you stop the operation of 11B?
your lordship, it is admitted to probably of the land. And the utility of the law code was high level supporting the dear lordship. That's of order of the different forms. We refunded the money.
Hmm?
We refunded the money. This was correct.
First of all, refund if it is within that period of demand, if you can satisfy that, perhaps you can make out a case. But for the earlier period,
That is there. Our contention is only
yes, the demand for refund is within time. You have to, once it is refunded on the basis of the court orders, you have to pay that back. You can't defer that payment.
And then lordship was executed 2002 pay SSC they executed guarantee in favor of the department. Subject to 10 SCC base 74. Very good. Paragraph 2. The SCC manufactures block code. It's subject to the classification is defined block code under the section bill the assistant commissioner did not accept the classified in the 4.08 objective research with the SSC page. And the respondent will be such classification was dismissed. The SSC page filed the bill before the judgment. The respondents convention and allow that the review before an appeal is in the court. Stay. The review is funded. The SSC that it is at pay. Respect thereof. The respondent gave an ability to the amounts funded within the event of the school. And already granted to the commission 6 months as emphasis on the section that is
Where is the direction to make a refund? Which page? Yes. You said that you refunded the amount. This is on the basis of which order.
Page 16, one comes up.
Sorry, Mr. Kerala, we did not hear you. Please repeat again.
Page 16.
1-6. Demand come shows notice. No, I am asking you is actually this. I'll tell you why this question has come. Come to page 62. Para 6. Just last 4 lines. The duty was finally paid by the SEC, but after the order was filed by the travelers by the High Court, they did not pay the duty. The department also did not demand the duty. For the duty already paid by them, they claimed refund claim. They preferred demand claim, which was ultimately refunded by the department. So therefore, this is a transaction between you and the SEC. It was not on the basis of the order of the court. Therefore, question of refund when it comes, again 11B will come in. That's why the pinpointed question.
Page 16 last one.
16 last time. No, that is okay. That's, you see, this is perspective. Supreme Court does not say that the reciprocity demand can be
Page 670.
70. Yes.
First, page 67 lakhs. Funding to pay of the period from 28.
Correct. But that is, you see, without any intervention of the court. They made a claim and you refunded it. So you see, a claim of refund will be just like any other money claim. Once it is refunded, why 11B will not attract it? No, you see, you see, when it comes to excise, and perhaps one of the judgments cited here also says same. You see, what we understand, subject to correction from you, once a demand is made, the demand has to be satisfied. Correct. So, but if supposing there is an erroneous assessment made and the SEC makes a demand, you make the refund without any undertaking, without any what you call a rider that once it is adjudicated against you, then you have to pay back. So it was not under protest. One of the judgments cited by you.
In that case, also it is not. That situation.
So therefore, in one of the cases cited by you, there is a statement made that the refund has been made under protest. One of the judgments cited by
It is
you.
not.
So therefore, if it is not under protest, it will be just like any other claim under 11B. That is why you are asking that question.
Here also it was because I go integrity of which category will fall.
see, I am a manufacturer. I manufacture this with an idea that this is a excise, what you call liability of, say, 0 rupees. Okay, so I manufacture this product. After 10 years, if there's an adjudication which says that no, this year the tax liability, excise liability was 10 rupees.
Then it is, because that is a quite different matter. Here also, what happened, initially when the pilot began, because we are selling, they said that in Canada, that was visited by the demand. And that was challenged before the authority.
No, in this case, they did not challenge it.
They hear that they check.
So therefore, it will presume it that there was no demand from your end.
Because the product was seen. Product which was under
Yeah,
challenge,
that's okay.
that was decided. Because also flexibility will be depending on the
It shows that is the only question you show us that the taxability will be on the basis of future adjudication. Because you see, future adjudication will be a basis of review of tax.
There is no question of feasibility. Because it is a provision, they identify return under section ST12.
But you accepted everything without any protest. You did not put the respondent to notice that once this adjudication is made, then you will be liable to tax.
Or under ST2 returns, clarify whether they are not. On the ST2 returns, because they were filing regularly, they will clarify was whether they were or not.
No, you see, take a case, a hypothetical case. A man has an income of rupees 100. He submits a return on the basis of rupees 100. And there's a tax liability of 1 rupee on income tax of rupees 100. Correct. So he pays that, and you do the assessment, accepting 1 rupee as as his tax liability. Now, after 5 years, can you reopen that after the period of limitation and then say that no, now the Supreme Court has decided the tax on 100 rupees would be 2 rupees, and therefore you pay the tax. So maybe I'm just saying that it never it's not happening. So here also you see that when this returns were made annually, shows that it was not it was only a provisional assessment. Where is that? Because if you have kept it alive and they have not put it to challenge, then it's a different matter. But that is not the case projected here. There's not a single. Well, see, given an opportunity, every honorable judge will have a different question. I may have a different question. My sister is sitting silent. She is having a different set of questions, unconnected to what I am asking.
This question was put in the paragraph 7, page 77.
77. Yes.
While there is no dispute about the eligibility of the same, after the decision of the tax court, there is dispute between the applicant and department regarding whether assessment rate is reasonable or not. The lower has quoted the finding that the classification which as well as Article 12 were not family assets, that the relevant time in them to recognize only after the eligibility of the tax court decision. The specific point from the bench whether the formulary of certification of bond etc. will follow and whether there was a formal order of provisional assent. The submitted that the case is very important. The record of the relevant time was legally specific.
No, I don't know, but this is something which is not there in the pleadings. I did not observe this page 77. But in your, you see, on the list of enclosures, the provisional assessment orders are not even produced.
It's not there. It's not there. It's the convention of the department of the system.
It's okay, but today also it's not there.
It is not there.
then your claim fails.
In paragraph 7 also. Paragraph 7 is 77. This fee was taken by the department of the associate.
Then if the documents are not available, we can't do anything.
Paragraph 7 said fee was taken. Then the representative of the department justified.
Just a moment. There's a provision in this what they call this Central Excise Act of Rules regarding this periodical filing is filing or return is 1 month. What is the limitation within which you have to dispute the correctness of the return file? Which is the provision?
Normal time limit is 6 months. Was 6 months. Normal time limit was 6 months. And we
Under
changed
which provision?
under 11A,
11A.
section 11A.
In your
Page 3. In comparison,
three.
page 3.
11A. Because it is not even shocking. Huh?
Regarding changes not
No, because there's a time limit.
Yes, it is 6 months.
It is 6 months.
In case of normal, it is 6 months.
So therefore, if 11A is operated as when customer respondent is submitting, in that event, the demand made has to be stayed by a court which extends the period of limitation. If it is not there, then
Normally,
you can't help it.
we expect that normally we consider them equal the time.
So only because unless you see what I understand is in the tax regime we don't follow the morality principles. That morally he is liable to pay. That regime perhaps may not be attractive.
Time limit is the
So if it is not under protest, then I think we can't help you. No, you could you see the Supreme Court did not permit you to deny this to enforce that order on any SSC not before the court.
That is not.
It is not there.
That is not. This is not our.
Because rightly so, when 11A operates and the authorities are aware of it, they have to extend the period of limitation. 89 and today we are in which year? 23.
It was finally in 2019.
No, it's okay, but if I refer back to the demand.
But that is there.
It is there.
If it
Okay,
this is not our submission. This is not our submission. Our
principal ground is that Supreme Court says,
Okay, here.
because the stability was decided by the Supreme Court, because earlier it was like that for so the second benefit,
Yes.
I don't think I need to say much more. Before you was comment on it, one thing I need to show you actually. This page 16, 16. Page 16, 16. Because the query was going to your worksheet line with respect to the refund. Now, page 16, that is the type copy of the show cause. First paragraph will be. Now, kindly see. Towards the middle, it is recorded, that is the 5th line in the top, where granted a sum of rupees such and such, total rupees such and such as fund of central excise duties paid by them for their clearances of block books for the period from February 86 to July 89, with the adjudication order number such and such dated 14th May 1981, passed by the Assistant Commissioner of Customs. So, my refund for this period was by way of an adjudication order in 1991. So, that order was never questioned in appeal, either by the revenue or by me. I had no question or no circumstance to challenge it. We never questioned this. Limitation for preferring an appeal against an order under the Central Excise Act, Section 35. Plus 2 months. And further convertible up to further 30 days, 60 days plus 30 days. And in Steve's enterprise case, it has been held by the Honorable Supreme Court that it cannot be converted in further, even by the Honorable Court. So, this 1991 refund order reached its final. Now, how they have invoked this in the show cause notice, the very next sentence. Passed by an Assistant Commissioner, such and such were virtually tantamounting their clearances of block board at nil rate of duty for the same period. Now, were they issuing the show cause notice in July 1995 at the top of the date is here. They want to say that for this particular period, you claim the refund. In 1991, you have been refunded by way of an adjudication order, which was never checked. So that refund virtually tantamount to your clearance of the product, your product, during 86 to 89 under nil rate of duty. So today, since Supreme Court has said that it will be under the classification 4408, so you are liable for payment of duty for that period also. So I am invoking section 11A. Kindly come to page 17. The second paragraph, last sentence. I won't waste your watch's time. Page 17, second paragraph, last sentence. Sure, I'm reading from the top of the second paragraph. The said Assam timber products are therefore.
Page 70. 17.
Next. Sorry. Second paragraph. The said Assam timber products are therefore asked to support to the Assistant Commissioner of Central Tinsukia as to why Central Excise Duty amount into certain time. But this also includes that refund, because just before that, you will find the 3 periods they have covered. Should not be recovered from them on their clearances of block boards for the period from 86 to 90, 90 to 93, and 92 onwards under section 11A. What I was showing you launching. So they have not invoked proviso to section 11A. The Lordship will find section 11A as I have given to you Lordship. Section 11A provides time limit of 6 months. The proviso provides that if there is any fraud, collusion, willful misstatement, or suppression of fact, then the limitation will become 5 years. So, they have not invoked the limitation because they cannot say that there was any fraud, collusion, willful misstatement on my part. Because everything was within everybody's knowledge. So, I made the refund claim, they granted the refund in 1991,
Everything was new. There was no separation. So they have not invoked the extended. What they are trying to invoke? They are trying to invoke the 6 months period because the lordship takes again the date of suppose we get paid 1/6. The date is 24 July 1995. They are calculating 6 months from the date of judgment of the Honorable Supreme Court in the case of Woodcraft, which was passed on 20th March 1995. So from that, it is within 4 months. That is their case. No matter in my case, but foreign from your lordship, that in Woodcraft I was not a part. That was going on separately. I was not a respondent. Their final judgment in lordship has already pointed out that that was coming out of a common judgment passed by the Honorable High Court with respect to the other parties. So I am not the party in Woodcraft. But in my case, what happened in lordship will find. In my case, my appeal before this honorable court was dismissed on, my lord will kindly note the date, 23 March 1993. 23 March 1993.
Where is that? Your petition.
In my petition is now can you come to page 3 of the appeal?
That is the big facts, 23.3.
Yes.
But what is this? What is this repetition about?
My writ petition was challenging the classification. And the last sentence, he said interim order subsequently disposed of by the Honorable Guwahati High Court on 23rd March 1993. This was my case, admitted position. I will find the same fact at page 47, 4th paragraph. That is the order in original in the present case. So far as my case is concerned,
Where is the judgment of the Supreme Court?
that Woodcraft,
Is Woodcraft.
that cited, that is first one, Woodcraft is reported at,
No, do you have a copy of that?
I have,
Pass it on.
I have.
You just pass it on because again, to find it out in e-version is difficult. Then again, yeah, that's why reading in hard copy is always advantageous.
Yes.
You see, now come to this this first para.
First,
No, sorry, second para, third line. This decision being in favor of manufacturers, the appeals relating to the period allowed by the revenue for the second period, writ petitions filed by the manufacturers in the Guwahati High Court were allowed by judgment dated
Yes.
93 reported in so and so, and are covered by and are by the revenue against the said decision for the third period so and so. So now, even if that is not there, the actual challenge is not there, but now the Supreme Court has set aside the order of this court of 1993.
and there were different sets of
No, I understand.
these writ petitions where your lordship has rightly pointed out. The second set said for the second period, Guwahati High Court passed judgment dated 23/3/1993.
Yes.
Whereas these judgments were in favor of assessor when revenue preferred the.
Yes.
In my case, the judgment was against me. Well, coincidentally, the dates are same.
Oh.
Coincidence. But in my case, it was against me, saying that no, it will be classified under 4408. So, my lord, I accepted that order of this honorable. From 1993 onwards, my lord will not find any demand. My lord, we can come back to page 17 from again.
Yes.
See page 17. They have demand against me for at serial number 1 and serial number 2 at the top.
Yes.
Can you see the right hand side column? The period ends to February 1993. Why? Because after the order of this honorable court in my case, in March 1993, I started paying duty from March 1993.
Okay.
Because for March 1993, I had a time up to 10th of April 1993 to pay the duty. In the meantime, in my case, order came on 23rd March 1993. So my demand is up to February 1993, where I started paying duty. Now, my lord, they are trying to take a wild imagination, my lord, they are correct. Until, because this was pending, so they could not raise the focus of it, and from the date of settlement, 6 months time they will get. So in my particular case, the time started from March 1993. Even taking that into account, and we come back to page 16, the entire demand is beyond 6 months. That is my only case. Now they have taken a question of law. Your lordship has already seen at page 9 at top that tribunal has erred in law by asking for that formal order of provisional assessment. While in Samrat International, Supreme Court as well, it is not required. My lord, putting this question parallelly to the finding of the tribunal at page 77 at the bottom. And at the bottom, why I am saying, I will read from the word to a specific query. Very kindly mark. To a specific query from the page, whether the formalities such as execution of bond, etc., were followed, and whether there was a formal order of provisional assessment in the case. He submitted that the case is very old and records of the relevant time was not really traceable. Stop. Now, my lord, I am emphasizing the next sentence of the tribunal. Leaving it aside. This is not tribunal finding. Tribunal asked, tribunal left it aside. Leaving it aside, that it is obvious that the dispute has been going on for a very long time. So tribunal finding is not on the basis of that provisional assessment order formal was required, it is not produced, so no demand can be there. It is what tribunal order. Tribunal asked it, tribunal left it aside and said that everything was within the knowledge of the department, so no demand beyond the normal period of time, that is 6 months, is permissible. Now coming to the question of Samrat International judgment event, well, in my compilation I have cited 4 judgments. Well, we find these all 4 judgments are of Honorable Supreme Court much after Samrat International, and Samrat International has been considered by the Honorable Supreme Court in latter judgments and held that it was a wrong law.
Is it?
That question of law referring to Samrat International, that Samrat International judgment has been discarded by the Honorable Supreme Court.
Which case?
Yes, my lord. Kindly first take 1997-92, paragraph page 10 in my compilation. Yes, sir, I have been giving you a copy. Sorry, sir. Thanks. Now done. Look at the compilation. Sir, I probably have delivered to you compilation and 4 years from the last session.
We have to, in fact.
Yes, because I submitted it on 19th March 2021 before this honorable court, the copy to my understanding. And then 1997, 92 DLP, T0. Anyway, where it starts from page 10.
Yes, we have this.
Well, I have provided a copy.
Ah.
Here. Now also.
Oh, okay.
I will kindly take the judgment at page 10, running page number 10 of my
Yes.
compilation. The Coastal Gases and Chemicals Private Limited. Now I will kindly come to page 11, that is paragraph 5.
Just. It's referring to Samrat International.
Yes, 1992, 58 ELT 561.
In this coastal gases, it says that this is not a good law.
No, I'm sure. I'm sure. Now kindly come to paragraph 5, that is at page 11.
Yes.
Well,
Yes.
and the 6th lines, right hand side, the sentence starts, the appellants have.
Yes.
The appellants have relied upon the decision of this court in Samrat International, but the circumstances reported in 1992, 52 ELT 561. As such, where this court said limitation under Rule 11, well, the Rule 11 is the provisional assessment, well, that is given. Commences only from the date of final assessment. On the facts of that case, however, this court had held that the payment of duty, which was made by the appellants in that case, was provisional, and the procedure under Rule 9b had been followed. We have not been shown any material on record to indicate whether the appellants in the present case had cleared carbon dioxide manufactured by them by following the procedure laid down in Rule 9b, or that the payment of excise duty which the appellants had made during the relevant period was provisional. This is a matter which the appellants will have to establish before the departmental authorities when the matter goes back to the departmental authorities for considering the claim of the appellant or for refund under the issue of Mohammed. If the appellant succeeded in establishing the payment of duty which was made by them for the period in question was a provisional payment. They shall be entitled to the benefit of the issue. So, my lord, in this judgment, after considering Samrat instance matter, Honorable Supreme Court said that the procedure laid down in the Rule 9 has to be followed to establish that it was a provisional system. Mother, kindly take the next page, metal page, next page, page 12, and kindly take paragraph 11 at page 14. The next question for our consideration is whether the order made by the Assistant Collector on 21 January 1976 could be treated as a provisional classification so as to keep the period of limitation frozen. The judicial member in this regard came to a definite conclusion that the said order is a final order against which appeals and revision were taken recourse. Now, kindly come to the bottom of this paragraph, a perusal. After referring to Samrat International, a perusal of this judgment shows that the said judgment was delivered on the peculiar facts of that case and it does not lay down a principle of law. Which enables the revenue to treat every classification made by it or the goods removed by virtue of said classification to be treated as a provisional merely because some appeal or other proceeding is pending. Now, can you see the next paragraph, paragraph 12. From the above, it is clear that to establish that the clearances were made on the provisional basis, there should be first of all an order under Rule 9B of the rules, and then material to show that the goods were cleared on the basis of said provisional basis, and payment of duty was also made on the basis of said provisional classification. These facts in the instant case are missing. Therefore, in our opinion, there is no material in the instant case to establish the fact that either there was a provisional classification or there was an order made under Rule 9B empowering the clearances on the basis of such provisional classification. In the absence of the same, we cannot accept the argument of the revenue that in fact the order of the Assistant Collector dated 21st January 1976 is a provisional order based on which clearance was paid by the appellant or that they paid duty on that basis. On the contrary, as held by the judicial member, the said order of classification was a final order. Therefore, the revenue cannot contain the limitation prescribed under Section 11A does not apply. Now, the third judgment, my lord, in 2005, page 17, in Hindustan National Glass Industry, is a judgment by 3 judges, honorable judges, bench of the Honorable Supreme Court. In Hindustan National, my lord will kindly come to page 21, only one paragraph, paragraph 18, 180. There is one other point which needs to be noted, that is plea of the revenue, that the assessment orders,
Which
paragraph 180, page 21.
Oh, that's
Paragraph 18,
yes.
there is one other point which needs to be noted, that is plea of the revenue, that the assessment orders were provisional in nature. This plea is equally untenable in view of what has been stated by this court in Metal Forging. And the earlier judgment I placed before your lordship. In 2002, it was held that in order to establish that the clearances were on provisional basis, an order under Rule 9B of the erstwhile Central Exchange Rules 1944 ensured the rules, and clearance stroke payment of duty on provisional basis are essential. This was by this. Now the last judgment on the issue, my lord, so far my research goes, my lord, at page 22, Indian Refrigeration Industries by the Honorable Supreme Court. At page 23, paragraph 15, kindly see at page and paragraph 12, Samrat International has been relied upon on by behalf of creditors. Para 12. And on behalf of respondent, appeal and hearing, assessing from Metal Forging was relied upon. And thereafter, paragraph 50. In view of the subsequent judgments of this court in Metal Forgings Limited and Hindustan National Glass and Industries Limited, case Supra, the impugned order based on the decision of Somnath International Supra cannot be sustained. The assessment framed till the approval of the classification list on 17th December 1979 cannot be treated to be provisional. Well, today, before your lordship, the revenue is relying on a judgment to contain their first question of law, which judgment has been time and again discarded by the Honorable Supreme Court in the subsequent judgment, and it was categorically said that we established provisional assessment and order under Rule 9 years. Well, that is what the tribunal has specifically asked for, and they failed to produce even before the tribunal, even today, before your lordship. So the question of provisional assessment cannot arise. Now the second question is whether on, I'm referring to the second question at page 9. Whether Honorable Sestak is right in holding that there was no justification to demand duty beyond normal time limit, which was only 6 months from the date of issue of the show cause.
Yes.
The second question of page 9 is whether Honorable Sestak is right in holding that there was no justification to demand duty beyond normal time limit, which was only 6 months from the date of issue of the show cause. But I think this question your lordship has already dealt with when submissions made by on behalf of the revenue, and as well I could show your lordship that in this case, beyond 6 months does not arise, even if they want to take the plea of the pendency of the proceeding and judgment of the court. In my case, it was 23rd March 1993. So 6 months ends in September 1993. So, my lord, this proceeding was barred by invitation. The tribunal below has correctly passed the order. I pay for upholding of that order passed by the tribunal by dismissing the appeal referred to the revenue board. On the earlier occasion, I have filed a synopsis of argument, whatever I have submitted to you.
It's available.
If it is not available in the requirement, I can keep further.
So there is something filed on 10/3/21.
This was
Correct. 10/3/21. Okay. Yes, I think it depends. Yeah.
Some timber products on the basis of high order as referred to above abstain from payment of certain excise duty on the clearance of road or the subsequent period. Equally, Party High Court also ordered refund of certain excise duty paid by the same Assam timber products on the clearance of road from 8 to 26 on 2 months. Within 2 months, 5 CR number transfer within 24 months. Assistant Collector Secretary in compliance with the High Court's order concerning the amount of financial period from 28 to 26 to 27. Right? Some other requests say Assam Timber Products take central excise duty for the period from 29/6/92 to 1993. Show empty order for the
funds. Separation. The income of this two percent. Found finally it is the only scheme that delivered certain funds. Again, something which is coming from the period number 2 from 26 to 1992, 1992, 1992, and 1392. Was dependent on the decision of the
But Mr. SC study was for the Central Board of Indirect Taxes, as well as Mr.
Arijit Chakraborty.
Chakraborty, counsel for the respondent. This appeal under Section 35G of the Central Excise Act 1944 is directed against the final order number. Take it from the no. Just finding the order. Take that. And page 1 of the memo, okay, number is there. Final order number is also. Dated 1/12/2017, passed by the Customs, Excise and Service Tax Appellate Tribunal, within bracket CSTAT bracket closed, Kolkata, Eastern Zonal Bench, in Excise Appeal number capital E/70499/2013. By the said order, the learned CESTAT had rejected the demand for duty raised by the appellants on the ground that the demand was made beyond the normal period of 6 months from the date of issue of show cause notice. And accordingly, the original authority was directed to re-quantify and restrict the demand in terms of the ceremony. I believe that there was no justification to impose any penalty which was set aside. Next one. In this appeal, the case projected by the appellant is that the respondent is dealing in manufacture and sale of block board, inverted commas, block board, by assessing it under, what is it called, tariff
Chapter,
chapter heading,
chapter
under
tariff,
chapter,
CTH.
huh?
Chapter tariff heading, CTH,
Chapter tariff
heading,
heading number. You were doing it under 44
initially we were doing 4408.90
4408.90,
and we are paying duty.
and we're paying duty prescribed thereon.
After, from 28 February 1986, we made it under 4410
Okay,
and paid no duty.
okay, first one. However, on and from 28 to 1986, the respondent classified their product under chapter heading number 4410.90
10.90
and did not pay any duty, as under the said heading the product was classified with nil excise duty. First. This is the proposed notice page
16.
16. The Superintendent of Central Excise, Dumduma Range -1, issued a demand cum show cause notice to the respondent on 24/7/1995 by projecting that the respondent were granted sum of rupees 68,59,125.62 as refund of central excise duty paid by them for clearing of block boards for the period from 28 to 1986 to 25/7/1989 by adjudication order, capital A, capital O, adjudication order number capital V with a bracket 18 bracket closed 33 public refund public AC give a space, then capital DIG public 90 public 660-666 dated 14/5/91 dated page 16. Passed by the Assistant Collector of Customs and Central Excise, Digoi, which virtually amounted, resulted in clearance of block boards at nil rate of duty for the said period. It was also the respondent was also put to notice that for the period between 26/7/1989 to 28/2/1993, the block codes were cleared at nil rate of duty by classifying the same under subheading 4410.90 of the Central Excise Tariff, and that the Supreme Court of India, in the case of Collector of Central Excise, Shillong versus Woodcraft Products and others, from 1995 within bracket 77 ELT 23 within bracket is C. By its judgment dated 23/1995 confirmed the classification of block board under subheading number 4408.90 of the Central Excise Tariff for the period from 28/2/1986 TO2 13/3/1990, 23/1990 TO2 28/2/1992 and 1/3/1992 onwards. Accordingly, the demand as follows was raised. Page 17, 17. There's a demand, basic, special, number 2, basic, special, and then 3 total. We give it in one line. Which was made under section 11A of the Central Excises and Salt Act of 1944, read with Rule 173 within bracket 1 within bracket 2 numerical of Central Excise Rules of 1944, and the demand was required to be satisfied. And the petitioner, when the respondent was put to notice as to why the said amount should not be recovered within 30 days from the date of receipt of notice. Let's go. The learned counsel for the appellant has submitted that the mitigation with regard to classification, appropriate classification of the block boards was pending for a long time, and the issue received a quietus from the Supreme Court of India in its by its judgment, and the judgment passed in the case of Woodcraft Products Limited, Supra, whereby the classification of block board was confirmed under subheading number 4408.90 of the Central Excise Tariff. First, it is further submitted that the judgment of the Supreme Court of India was passed on 23/1995, and that the show cause notice was issued on 24/7/1995, which was within a period of 6 months, as envisaged under section 11(a) of the Central Excises and Salt Act of 1944. First, it is also submitted that the respondent has availed refund of the tax paid to the extent of rupees, excise paid to the extent of rupees. What is that amount which was refunded to you?
Standard page 1668, 59, 125.62.
What is the figure? Please give me again.
68,
Rupees
59, 125.62.
Just 68, 68,
8, 59,
59,
125.62.
125.62. And therefore, the issue of classification being settled by the Supreme Court of India, the show cause notice and demand made upon the respondent was within the period of the petition. So accordingly, it is submitted that the original order so this is a appellate order. The impugn appellate order passed by the CSTAT. Our Kolkata bench was on an erroneous premises, and the same is liable to be set aside and crushed. Upholding the demand made by the revenue. Yes. This, Mr. Khyar, you have given this written synopsis. You are referring to Civil Rule 282. What is this? This is a litigation of which parties? Page 1 of your note. Civil Rule number 282. This is a litigation between which parties? Huh? Respondent. Okay. Civil Rule number 282 of?
282/91.
Okay. This further submitted by referring to the written notes of submission submitted on behalf of the applicant that this could be order dated 11/1/1991, passed in Civil Rule number 282 of 1991. As an interim measure, permitted the excise authorities to levy and collect excise duty by classifying block boards manufactured by the respondent under subheading number 4410.90, which attracted nil rate of duty. Therefore, the respondent did not pay the duty prescribed under heading 4408.90, and that by an order dated 24/1/1990 passed in WBC 22, sorry, not the civil rule number 2228 of 1990, directed the excise authorities to refund duty to the respondent from 28 to 1996 onwards. This also submitted that this court, now dated 26/6/1992, passed in civil rule number 1199 of 2022, as an interim measure directed the respondent authorities to levy excise duty on block boards of the BENEED, BENEERED timber board at 15% ad valorem, pending disposal of the litigation, which was paid by the respondent for a period from 29/6/1992 to 31/1/1993. Later on, this court by a common judgment at 23/3/1993 in civil rule number 1500 of 1989, other connected cases, held the classification of the block board as under entry number 4410.90. Accordingly, appeal was preferred before the Supreme Court of India, and the Supreme Court of India in the case of wood craft products, Supra, confirmed the classification of the block board as 4408.90. Accordingly, which are the cases you are citing? So this four cases. So reciting these four cases, I wanted to submit that the issue of classification being settled by the Supreme Court of India by judgment dated 20/3/1995, demand was within the period of limitation and was sustainable, and that the period of limitation should be calculated after deducting the period of litigation on the issue raised before the Supreme Court of India regarding classification of the block board under the Central Excise Tariff Act of 1985. So it is also something that the said decision of the Supreme Court was binding on all the authorities. Hence, it is something that you can order set aside in fact. If you wanted to say something. Yes. From the General Counsel for the respondent has submitted that the respondent in order to challenge the levy under subheading 4408.90, had also prepared a repetition before this court, which was numbered as civil rule number. What is the number of your case?
One 1199 of 1992.
Where was that? You had shown it to us. Where was that?
Page 47.
47. And that their repetition was also disposed of by this court on 23. No, you're
Yes, fourth paragraph.
on 23/3/1993, dismissing the repetition and classifying the, and by confirming the classification of block board of the V fullstop T fullstop board under subheading number 4408.90 of the Central Excise Tariff Act. We submitted that thereafter the petitioner accepted this judgment and continued to pay. Continued the review of Central Excise under the subheading 4408.90. Accordingly, it is submitted that insofar as the demand of excise is concerned, same became time barred after 6 months from 23/3/1993. In support of the submissions, the Learned Counsel for the respondent is also submitted a written note of submissions. And as relied on the following cases. The second case. Next up. This appeal was admitted by order dated 9/12/2019 by framing the two main substantial questions of law. Questions. Green. On a perusal of the materials of record, the applicants has not been able to demonstrate that there was any provisional assessment made in respect of payment of excise duty for the period from 28 to 1986 to 25/7/1989, and from 26/7/1989 to 28 to 1993. The it would be relevant to extract the provisions of section 11A of the Central Excises and Salt Act 1944. This is a little bit
11A, sir. Section 11A.
11A. capital. Next. The applicants have also not been able to demonstrate that the respondent had not paid the appropriate excise duty by reason of fraud, collusion, or any willful misstatement or suppression of facts, or in contravention of any of the provisions of the said act. So therefore, the appellant has not been able to make out the case that the period of limitation should be extended for a period from 6 months to 5 years. First, in any case, the appellants have also not been able to demonstrate that the writ petition filed by the respondent, IWBC 1199, number is correct, 1199,
Yes.
of 1992, was not dismissed by order dated 23/3/1993, after which the respondent started to pay excise duty on the logbook under subheading number 4408.10 with effect from which date?
Which effect from March 1993.
With effect from the month of March 1993. In the absence of any material before this court, that the assessment made in respect of the petitioner for the period from 28 to 1986 to 25/7/1989, or from 26/7/1989 to 28 to 1993, were provisional, and that the same was translated in the final assessment order pursuant to judgment of the Supreme Court of India in the case of Woodcraft Products within brackets Super. Next. The learned counsel for the appellant had placed reliance on the decision of the Supreme Court of India in the case of Samrat SAM RAT International Private Limited versus Collector of Central Excise, 1992, in bracket 58, bracket was ELT 561, in bracket SC. It is based on this set citation that the first substantial question of law was formulated. To counter the said citation, the case citation, the learned counsel for the respondent has cited for decision of the Supreme Court of India referred hearing before to demonstrate that the judgment in Samrat International Limited Sutra was passed under the peculiar facts of the said case. And that as the appellant, and it was projected that as the appellants could not demonstrate that the clearance of the block boards was made by following the procedure laid down in the Rule 9 capital B of the Central Excise Rules, the revenue would not be benefited by the said cited case. In the said context, what is inclined to reproduce the 11 and 12 of the case of metal forgings with a METL, metal forgings required GINGS within the circle. Hindustan National Gas, sorry, paragraph 18 of the case of Hindustan National Gas and Industries Limited within the Sutra. And paragraph 12 and 15 12 to 15 of the case of Indian Refrigeration Industries within the Sutra. Next. From the above, it is from the above and from the facts of the present case, where the demand, alleged demand of the appellant was not on the basis of any provisional assessment, comma. What is inclined to hold that the impugned decision of the CGEST, CSTAT, to reject the contention of the appellant of the claim in time bar is not liable to be interfered with. First. Next. Where is that observation? Page 68. It is noted in the opposite context. It is noted that in the order in appeal number 02/DIB/CE within bracket capital A bracket /GHY /13 dated 21/1/2013. This number you find at page 56, comma, in para 6 thereof. It has been recorded that the duty leviable the duty was finally paid by the SSC, but after the order was passed by the tribunal as well as by the High Court, Guwahati, they did not pay the duty, and the department also did not demand the duty. And that for the duty already paid by them, or the preferred refund claim, which was ultimately refunded by the department. Paragraph 6 of the set of is quoted page 62. First, the aforesaid factual situation not be demonstrated to be erroneous finding of the learned by the commissioner in the appeals. Next, therefore, the court is inclined to hold that in respect of substantial question of law number 1, the court finds that the perspective in which the learned CESTAT had given emphasis on the formal order of provisional assessment was justified. And he said, question is answered in the affirmative and against the opponent. In the absence of any document to show that the assessment made by the appellants were provisional, no reliance could be placed on the case of Samrat International within bracket Supra. In respect of the discussions about trauma, insofar as substantial question of law number 2 is concerned, the court is inclined to hold that under the facts of this case, the respondent started paying excise duty under subheading number 4408.90 pursuant to judgment of this court dated 23/3/1993 in civil law number 1199 1992, and that on their application the refund was made by the department, and I think it's shown that the refund was made subject to the issue of classification being settled by the constitutional courts. Therefore, the court is further inclined to rule that the cause of action, insofar as the demand for excise from the respondent is concerned, the limitation were done from 23/3/1993, which is 6 months from the 6 months as per section 11 capital A of the Central Excises and Salt Act 1944. And therefore, the claim of duty and refund and recovery of refund is found to be barred by limitation, and therefore the second substantial question of law is also decided in the affirmative and against the appellant by holding that the finding of the CESTAT warrants no interference in holding that there was no justification to demand duty beyond normal time limit, which is only 6 months. Next. Accordingly, both the substantial question of law decided against the appellant. This appeal is dismissed. There should be no other post. These are the written submissions. This is the written submissions. And this is the act comparison of acts and the judgments. I hope I've not missed out any of your arguments because I touched central exercise after a long time. Huh? No, I don't know. This is why I asked you because exercise I touched after a very long time.
You only left because GST has come and only few left. Have not been able-
No, not that. But whether the applications are in the right order or not, this is a question which has to be tested.
Yes, maybe. I don't think in this case it will again be.
No, it's not. We are not. Only the question is that having touched after a long time, whether the manner which I have proceeded is right or not. Okay, I think I have to rise. There is a single bench which I have to deliver on the judgment. Other matters I will not be able to take up. Yes, you are asking for a date, fixed date, because since you are coming from out of station. Pardon me? No, tell us a date when you want. Any date in November. You choose a date, we'll fix it at your convenience. There's a calendar in front of you. No, there's a calendar of our court. Oh, is it not? Okay, we'll get a new one tomorrow. You want to do it on Children's Day? You want to do it on Children's Day? It's okay, we'll fix it on that day of your choice. Mr. Kyan, you are for the no inconvenience on that day? Oh, okay. Both sides are going to be presented. Due to positive time matter could not be taken up today. So as agreed to both sides, this was hearing on 14/11/2023. Okay.
Item 20.
Maybe in the second week of November. 16.
15. Okay. Item number
16. Item 20.
20. No, but for this bench, all days are same. 15, 16 doesn't make a difference. Oh, okay. You want it on 16?
16.
Item number
20.
20.
Same.
Same.
Item 23.
Yes.
I can take one. If possible, this month actually I have a pressure from my client.
Okay, no issue. We 21st September. 21st September. Oh, okay. So 26th.
26.
One day before.
25th. Okay, no problem. 25th September.
Logic of the supplementary item number 27, which is content of party. Can you take it on Monday, 11th?
7th.
Yeah.
Positive time. This one 9. We'll have to raise as a single. The reputation is dismissed on this petition is dismissed on merit as well as on the ground of suppression of material facts. Interim order passed on 19/1/2020 is vacated. The interrogative applications are also closed.
Item number 2 for orders.
Yes, Mr. Goswami.
Make it also. So there is some typographical error in this is the issue.
It's 6. It's 6 of the judgment.
No, this is of the potato.
Oh, acha. It's 6. Yes.
Consequence, I think it is, let's say, if fisheries are removed, it should be fishes are removed.
Oh, acha.
And second line, allow him to leave the fishery with the fishes containing in the fishery. So it should be allow him to leave the tank number 1, 2, 3 or the fishery after removing the fishes from the tank in question. It also, paragraph number 10. Orders shall not preclude the respondent APC to take such appropriate steps as they may so desire in respect of the fishery in question, which includes settlement of the fishery by safe public settlement in a transparent manner as invested for the settlement of the fishery in question. A paragraph should have been proceeded with the word after removal of the fishes from the safe tank within time. Otherwise, also it will make an objection in that part. During
No,
time.
just one. Para 9.
If the fishes, fishery with the fishes.
I will leave the fishery with fishes containing in the fishery. So what is wrong there?
Also, we have to leave the tank number 1, 2, 3 after removing the fishes from the tank push. Otherwise, it will be incomplete. Procedures allow us to remove the fish from the tank in question 1, 2, 3.
Okay. You want that to be clarified.
Lots. And we have given a certificate to the Lochib has passed the judgment on 2/18/2023. Now, without time.
Yes, Mr. Sharma. We can clarify this 1, 2, and 3.
Yes, just one thing here, one just time limit also. That's what I have objection. I have not sure.
We are given 10 days time.
10 days time to
No,
get
not 10 days time is not there. It was not clarified also. And you.
So para 9 it is 10 days.
No, Lordship, 10 days, Lordship, which is how, the Lordship has given us time to give them time, 10 days.
Huh.
We are not given any 10 days. We are not given any time. In our
We have not, after
Lordship,
No, here we have said, we said authority shall provide the petitioner an outer period of 10 days from the date on which permission is granted.
oh, but that means if we do, the time limit is not there in that case, Lordship. That means after, we should give them 10 days time to remove the fishes.
10 days from the date you pass an order.
Lordship.
This order, para 9, it says from the date you pass an order. That
Yes.
means there is an order to give them 10 days time.
Yeah, oh, there is an order to give them 10 days time. Yes, that's correct.
But it should be from the date of order which you are passing. You
Yes.
can't come up and say that no, we are not giving you a time of 10 days.
Lordship, yes, we are, Lordship, with respect to this part, during that period, we prefer an appeal, Lordship. During that part, during the time limit, Lordship, it is not in listed, Lordship.
You have filed an appeal.
Yes, Lordship.
Okay. It's okay, but we sustain the same, only the language.
Lordship, here,
correct.
Lordship, as per our understanding, Lordship, our understanding is that if we pass an order giving them permission to extract the fishes, then we should give 10 days time.
No, we don't give that liberty.
This is our understanding. Lordship.
No. That can't be. But we will test it in the appeal, there is no issue. But this will clarify.
Lordship.
Para 9. Mr. SK, this one also for the applicant and Mr. P. Sharma. And standing console for the here for all. We are looking for all. This is Sharma. Okay, respondents. Next paragraph. No, 2 to 5.
Only one is done.
2 to 5. 2 to 5. Next paragraph. This the central of the key application has been preferred for correction of the order. Stop. It is in this regard, it is submitted by the learning council for the applicant that the petitioner petitioner was carrying out fishery in tank number 1, 2, and 3 of the concerned fishery, and therefore the self reference may be added in paragraph 9 of the order.
Para 8. Fisheries are removed. Fisheries are removed. Para 8.
Para 8.
Line number 2.
In para 8, where reference is made to in inverted commas, fisheries are removed. In this said, we have it submitted that because the fishes which are to be removed are not the fishery, which is to be clarified. Then right. The by contract of the learned counsel for the respondent numbers 2 to 5 has submitted that there is the order dated 2/8/2023 passed in WBC 6742 of 2022. However, the respondents have already preferred an appeal, and accordingly they submit that the time limit for removal of the fishes may not be granted as the respondents do not intend to grant any permission to the petitioner to remove the fishes. First. With regard to the submissions made by the learned counsel for respondent numbers 2 to 5, the court is of the opinion that it is for the said respondents to take a call as to whether they would comply with the directions contained in para 8 and 9 of the order of this dated 2/8/2023 passed in WBC 6742 of 2022. Nonetheless, the applicant seeks clarifications in the order so as to remove the fishes from tank 1, 2, and 3 of the said fishery. which appears to be in consonance with the stand taken in the petition. Accordingly, the word fisheries appearing in the second line of the order of the second line of Para 8 of the order dated 2/8/2023 is substituted by the word fishes. Stop. In next paragraph, in paragraph 9, the reference to type number 1, 2, and 3 of the fishery is included. First, it is included within the words, word commas containing in and within inverted commas the fishery. First, next, the substitute paragraph 8 and 9 shall now read as follows. 8 and 9, page 20. Correction. Okay. Reference to tank number 1, 2, and 3 are added. We are not saying anything with regard to any other matter. And this fisheries is substituted by what fishes?
Yes, thank you. Time limit is not.
10 days is there, it's already there.
So they have interpreting that time limit is.
No, let them enter. This is why I said I'm not making any. They are doing it at their own. They will have to take their own call, whatever they understand. You can always prefer a contempt. Different too. Because once he has filed an appeal, it will be improper for me to say anything more.
We have also done career procedure from information. We have also filed career.
It's okay. Once Mr. Sharma comes to know what it is, give you a fee.
The process comes whenever.
No, it's okay. I'm not saying anything, but he is not unfair. I can say that. He's not
It will be
unfair.
given lordship.
It's okay. I'm just saying he's not unfair. Yes.
Item number 3 for hearing.
Item 3, we'll have to adjourn it. We can't take up now.
If we lost it convenience, it can be taken out on 14th March. Thursday.
Yes. The paucity of time matter will not be taken up today. This being a pattern matter list from 14/9/2023. But I have a meeting again right now. So,